Donde sir, shall we start or we need to wait for some time?
Hello, good morning, Pawar sir. Can we start? Hello.
Yes, sir. Yes, sir.
Okay.
70 plus are there, no?
Yeah. So, Zabiri madam, you can start.
Hello, good morning all. Esteemed speaker of today's webinar, Dr. Kantilal Nagre.
Namaskar, madam.
Pooja Menon. Namaskar, sir. Dr. Dinesh Wanule, respected principal, Dr. D.V. Pawar, CDC Chairman, Advocate Neil Helekar, sir. D.E.S. Office Bearers, Prabandhak Dr. M.B. Kenkre, Self-Finance In Charge and RPC Chairperson Dr. Seema Saple, Vice Principals Dr. R.B. Kaude, Dr. Minal Mapuskar, Professor Vittal Sontake, IQAC Coordinator Professor Matthew Samuel, Dr. Subhash Donde, Organizing Secretary of today's webinar, Convener Dr. Vanita Kamath and Co-Convener Dr. Mahajan sir, other dignitaries, faculties and students. I, Dr. Chetna Zaveri, on behalf of Deccan Education Society's Kirti and Doongursee College, welcome you all for National Webinar on Legal Dimension of Intellectual Property Rights, organized by Internal Quality Assurance Cell and Research Promotion Committee to propagate the significance of intellectual property rights amongst the teaching community and students. IQAC of Kirti College has been actively organizing various programs which includes IPR seminar, MOOC workshop, academic festival Shrujan, CAS workshop, environmental awareness and sustainability program, gender sensitization, research promotion, and many more. The Research Promotion Committee conducts various seminars, workshops to promote research among the faculties and students at Kirti College. Kirti College gives institutional funds to the faculties to carry out research in their respective discipline. Our institute promote and encourage faculties to present research paper under the aegis of RPC. We live in a world in which the economic health of nation and the competitiveness of a firm is determined largely by ability to develop, commercialize, and most importantly, to secure economic benefit from scientific and technological innovation and invention. Intellectual property rights such as patents, copyright, trademark, industrial design are important means used by firms to help safeguard their investment in innovation and invention. Research Promotion Committee has been organizing IPR awareness program for the past 3 years. Today's IPR awareness webinar aims for sensitizing and disseminating awareness about the patent law as the rest of the areas of IPR have been discussed earlier. Once again, I welcome you all and I invite our principal Dr. D.V. Pawar sir to welcome you all and share few thoughts on today's theme. Yes, over to Pawar sir. Thank you.
Yes. Thank you, madam. Thank you. And namaskar. Good morning to one and all. Respected CDC Chairman, Sri Advocate Neil Helekar, as well as the Trustee of Deccan Education Society, Dr. M.B. Kenkre sir, who is the Prabandhak of Deccan Education Society, today's resource person for this online webinar, Dr. Kantilal Nagre sir from Birla College, Ms. Pooja Menon from Ododara, and Dr. Dinesh Wanule sir from Birla College, office bearers of Kirti College, members of IQAC and Research Promotion Committee, and dear participants from various states. I, Dr. D.V. Pawar, Principal of Kirti College, welcomes on this virtual platform for this national level webinar on legal dimensions of intellectual property rights. Sir, we belong to the Deccan Education Society. The Deccan Education Society is one of the oldest and renowned education institution in India with over 137 years of dedicated service to the nation in the field of education. Deccan Education Society was founded in 1884 by eminent national personalities like Lokmanya Tilak and Gopal Ganesh Agarkar. The Deccan Education Society at present has 59 educational institutions from pre-primary stage to post-graduation and research levels in arts, science, commerce, management, nursing, physiotherapy, etc. Our alumni includes intellectuals, industrialists, politicians, defense personnel, literatures, and sports persons of highest caliber who have rendered valuable services to the nation. Ladies and gentlemen, Kirti College was set up in 1954 to impart higher education to the first generation learners of the surrounding areas. Currently, along with the undergraduate programs, arts, science and commerce, our college also offers self-finance programs in IT, computer science, BMM, BAF, BMS and biotech. We have postgraduate programs in English, economics, political science, chemistry, zoology, computer science and information technology. Besides, we also have PhD Research Center for Chemistry and Zoology. I would like to inform you all that our college has been aggregated with A grade by NAC in last 3 cycles and has been awarded with Best College Award by University of Mumbai. Our college is also known for its excellence in the field of sports, NCC, NSS and cultural activities. Ladies and gentlemen, we all are aware of that there are 2 types of assets, namely the tangible or visible and intangible or invisible assets, and intellectual property being a non-physical property is a form of intangible types of asset. Intellectual property rights are exclusive rights that are given to the person over the novel creation of their minds, such as scientific inventions and literary or artistic works, as well as symbols and images used in commerce, and these rights are protected against unauthorized use without the consent of the creator. Filing of intellectual property patents in India rose 30% in the last 5 years, while the number of patents granted during the same period almost tripled, according to the Economic Survey 2021-22. The increase in patent filing boosted India's ranking in the Global Innovation Index from 81 in 2015-16 to 46 in 2021. It also coincidence with the recent startup boom in India. To encourage startups to file more patents, the government provides incentives startups recognized under the Startup India. Programs get up to 80% rebate on patent filing and 50% rebate in trademark filing. However, the number of patents granted in India remains a fraction in comparison to the China, USA, Japan, and South Korea. This disparity is attributed to the low expenditure on research and development in India, which was 0.7% of the country's GDP in 2020. Procedural delay and complexity are some of the other factors that have deterred many from filing patents in India. According to the survey, the average time taken for the final call on granting the patents in India in 2020 was 42 months, However, this remained much higher than the 21 months taken in the USA, 20 months in China, 16 months in South Korea, and 15 months in Japan. The present government is also very proactive with respect of IPR, since automatic issuance of electronically generated patent and trademark certificates has also been introduced. Friends, though there are 4 different types of intellectual property rights such as patent, trademarks, copyrights, and trade secrets, today's national webinar will be concerned with only the patent and its legal dimensions, since other forms of IPR were already covered in our previous 2 national webinars. On the behalf of Kirti College, I once again welcome you all for this wonderful webinar on very relevant topic of modern era. Thank you, and over to Chetna. Thank you, madam.
Thank you, Pawar sir, for sharing your thoughts on IPR and briefing our college and give brief introduction of our college. May I now invite Organizing Secretary Dr. Subhash Donde sir to explain theme of today's webinar. Over to Donde sir.
Thank you, Dr. Chetna Zaveri, madam.
Yeah.
Good morning and warm welcome to one and all. Respected resource persons of today's national webinar on legal dimensions of IPR, namely Dr. Kantilal Nagre, Dr. Dinesh Wanule, and Miss Pooja Menon. Respected Chairman of CDC, Neil Helekar sir, Principal Dr. D.V. Pawar sir, Prabandhak Dr. M.B. Kenkre sir, Vice Principal Dr. R.B. Kavde sir, Professor Vittal Santakke sir, and Dr. Vinal Mapuskar madam, IQAC Convener Professor Matthew Samuel sir, and Chairman of Research Promotion Committee Dr. Seema Saple madam, all office bearer of Deccan Education Society Pune, and dear participants. Myself, Dr. Subhash Donde, the organizing secretary of this national webinar, is standing before you on this virtual platform to present the concept note. Dear friends, the Homo sapiens evolved from ancient caveman with the brain capacity of just 500 cc to the present day superhuman being in the era of 5G and artificial intelligence with the 3-time brain capacity of 1500 cc. In this evolutionary journey, the progress and well-being of humanity was an outcome of his quest and capacity to create and invent intellectual property in the field of science and technology, as well as art and culture, and obviously during the course of time, the need to protect his intellectual property was vigorously felt. And in this quest, the importance of IPR was first recognized way back in 1883 and 86 in the form of 2 international treaties which are now administered by the World Intellectual Property Organization, or WIPO. IPR was subsequently outlined in Article 27 of the Universal Declaration of Human Rights. These exclusive rights are given to the persons or over the novel creations of their minds, such as scientific inventions and literary or artistic works, as well as symbols and images used in commerce. At national level, with respect to our commitment to protect IPR, India being a member and signatory of world organizations such as WIPO and WTO, and is fully committed to the agreement on TRIPS. The national IPR policy was adopted in May 2016 as a vision document to guide future development of IPRs in our country with the clarion call, Creative India, Innovative India. Dear friends, this is the 3rd national webinar on IPR by Deccan Education Society's Kirti College and is in accordance with IPR awareness or outreach and promotion objective of the National IPR Policy of 2016. The objective is to create public awareness about the economic, social, and cultural benefits of IPRs among all sections of the society, and institutions of higher education like colleges and universities are just the right platforms to do so. It is not out of context to state that the very success of India's flagship program such as Make in India and Startup India is largely depends on the boost to the innovation ecosystem with better and efficient IPR safeguards. In this regard, more awareness is needed about the creation, protection, and enforcement of IPRs, and to encourage the fellow Indians not only to innovate but also to protect and enforce their innovations. Therefore, friends, this third webinar by Kirti College is specifically on the legal dimensions of IPR. It will hopefully reinforce the awareness in academia and researchers attending this webinar, specifically regarding to the legal and legislative framework of patent laws in India. Before I conclude, I am extremely thankful to all resource persons of today's webinar for accepting our invitation on ultra short notice. Really, this webinar will not have seen the light of the day without their wholehearted support and acceptance. Thank you once again to one and all attending this national webinar. And now over to Dr. Sanjay Sonawale sir, who will introduce today's keynote speaker, Dr. Kantilal Nagre. Dr. Sonawale sir.
Sir, please unmute yourself. Sonawale sir. Sonar sir are not audible. Please unmute yourself.
Yes. Thank you, Subhash Gonde sir. Good morning to one and all present here. Myself, Dr. Sanjay Sonawale. It is my privilege and honor to introduce today's guest speaker, Lieutenant Dr. Kantilal Hiralal Nagre, Department of Zoology, B.K. Birla College of Arts, Science and Commerce, Kalyan, Thane. He has completed his post-graduation in MSc Zoology from Institute of Science, Mumbai, and PhD from Ram Narayan Ruya College, Mumbai. At present, he is holding the position of ANO in Naval NCC of Birla College. He has authored more than 6 textbooks for undergraduate students, that is FY, SY and TY BSc in zoology on behalf of Mumbai University, Mumbai. And above all, his core area of interest is converting research or an innovation into a successful patent. Some of his patents are granted in the area like eco-friendly synthesis of nanoparticles of copper oxide, cobalt oxide, lead oxide using lac extract. So he has got 3 patents granted in these area from 2016 to 2017. Above this, he has also devised an portable analytical device for screening blood samples and parasite. Then he has also devised robotic teaching maps, excelled air disinfecting systems, and solvent extracting machines. At present, he has filed 12 patents, out of which 6 patents has been granted successfully to his credit, and other 6 are in the process of getting the grant. On patenting, he has addressed more than 25 keynote addresses in national, international conferences, workshops, and seminars, which clearly demonstrates the authority on the subject. Sir, we are eager to hear you and know you more about patents. May I request Dr. Kantilal Nagre to take up the charge for his keynote address. Over to Kantilal Nagre.
Thank you, sir. Thank you, Sonawale sir. I thanks to the management of Kirti M. Doongursee College, Deccan Education Society. Thanks to Pawar sir, who is the principal of Kirti College. Thanks to Kavade sir, Vice Principal, Vittal sir, Vice Principal, Minal Mapuskar Madam, Dr. Vinal Mapuskar Madam, again Vice Principal. Again thanks to IQAC Coordinator Samuel Matthews sir, the organizer which are present, Research Promotion Committee Chairperson Dr. Seema Taple Madam, and Organizing Secretary Dr. Subhash Donde sir. Thank you Sonali sir for the nice word about me. I am in patent field for last around 6 years, and in these 6 years I am granted with 9 patents, and another 6 patents are already applied. And right now I am working on another 8 patents. Before this time, before 2016, I was writing research paper, but now I am in patent field and I am expert in patenting. Let us move to the topic. I think my screen is visible.
Yes, sir, it's visible.
Yeah, thank you, ma'am. And I'm audible also properly. Yeah.
Yes.
Uh, you must have conducted a lot many webinars and seminars about the patent and patenting. My intention is different. My intention is to teach the trainers, to guide the PhD guides and research scholars to convert the research work into patentability. We teachers, we PhD guides, we are students of PhD, there are students of post-graduation level, there are students from commerce and every faculty. They know the research. Where we are lagging behind is to convert the research into patentability. And there is the lacuna. And my intention is to fill that lacuna. In today's webinar, we are having three different speakers. Myself, Dr. Dinesh Wanule, and Pooja madam. And our intention is same. Our intention is at the end of the speech, at least 5 of you can be PhD student, you can be research scholar, should get the knowledge of converting your research into patentability, into patent. That is our intention. This is the certificate of the patent is shown over here. I share you with the happiness. When I was PhD, I was given the convocation certificate by University of Mumbai, and my happiness index was 10. And same happiness index was maintained when I got such a certificate of the patent. You can see it is with the 3 lion. You can see with the red mark lion, because the certificate authority is President of India. You can read on the certificate, Bharat Sarkar, Government of India, Patent Karyalayah, Patent Office, and below that design number is mentioned. This is my last year patent. You can see design number 330878 and date is mentioned as 30 June 2020 with the timing 2018-18. रात को 8:08 18 मिनट और 18 सेकंड में I got this patent awarded. And below the paragraph, entire paragraph is filled with the title of the research for which the patent certificate is given, and then the name of the inventor is also mentioned there. Already Pawar sir has mentioned that the timing in India for the patent certificate is 41 months. Yes sir, it is there for utility patent. But timing for the design patent is only 3 months. It is modified. It is modified. If you apply today, within 3 to 4 months, you get the patent awarded for your design, and that in detail, I'm going to talk in the due course. Another patent which is granted on 9th July 2021, and after that again 3 more patents I am granted. See here, again the certificate of registration of the design by Government of India, and I was again happy with the same patent. But then why to go for the patentability? Why to go for patenting? Why to go for patenting? The basic need of patenting is that there is a deal link between the industries, the companies and research organization with the researcher who have great potential of research. Great potential of research. But we select the topic of our own and we publish the paper, and then there is a paper is at our credit, and then we stop. Okay, I published 6 papers this year with so and so impact factors are happy. Yes, This is also needed. Why not to think that if I do some type of research and if I design it and if I sell it to the company will come with the new product and that product will be helpful for the society. The product will be patented for the society. So now let's read my first patent, eco-friendly method of preparation of iron particle. I'm in touch with the pharmaceutical company who will be in coming year with the tablets of heme. If someone is suffering from iron deficiency, this nanoparticle will help with him for increasing his taking over the hemoglobin deficiency, heme deficiency. We are working on that aspect. And then pharmaceutical company has approached me and even I approached them because I am successful in preparing the ferrum nanoparticle with the size of 3 nanometer. With the size of 3 nanometer. There's a dealing between industry who don't know what industry want and industry don't know what type of research we are doing. There are companies, they do their own research, they have their own research field, they have their own research committee. Scientists are working on that. But sometimes our expertise, our micro expertise, they need drastically. I'm in touch with many pharmaceutical company and they're asking for such micro expertise they want. And we need to patentability, we need to go for patent because company don't know what type of research you are doing unless and until you patent it. So there is a dealing between industry and patents. Next is application of current research for doctoral degree. We go for the PhD, we register student for the PhD, they work for 3 years, 1 year they write the thesis and they submit it. Good. So the student is getting degree, good. But 50% of the students who pass out with a PhD, they come to the guide and they ask one question. Sir, आता मला पुढे काय, मला नोकरी कुठे मिळेल? माझ्या भवितव्याचं काय? If the thesis contains such a patent certificate and if it is with a degree, with the PhD degree, if the student is with the patent certificate in his thesis, think of the value of his own thesis. We can very well approach to the company, and if analog, the company may absorb him. The chances of getting job are more. Make in India movement and Swarnim Bharat movement, these are started by Modi sir. Long back in 2014, I read one article. There was a research met called by Modi sir and all the GGC director, IIT director, they were there in the meeting. And Modi sir told me, Modi sir asked them, I don't want to know about what type of research you are doing. I am interested to know how many patents you got. And it was in 2014 when Indian patent granted were 4,200. Rightly said by Pawar sir, this year Indian patent granted are 29,000. You see, most of the patent granted are in technology. Even my 5th, 6th and 7th patent, which Sonali sir read about invention of the instrument, are of the same type, Make in India movement and Swarnim Bharat movement. Entrepreneurship. Don't ask for the job, create job. मला कोण नोकरी देईल? नाही, मी कोणाला नोकरीवरती का ठेवू नये? Create job. When you can create a job, when you have something technology with you. And designing patent is a technology. You prepare a design, you approach to the small scale industry, you can start your own unit. The small scale industry unit around 3 to 5 crore, you can very well start. For the small scale unit, if you apply to the government of India with the patent application as per the government law, clause number 135, the patent is granted in 6 months, and for such a patent, the economist people are there listening to our talk. Around 85% loan is granted by the government of India if it comes under Make in India new invention type. Middle scale units also recognize the patenting person to appoint their own organization. Last point is API. This is for the government officials, like we all teachers. Very sad to say, but last few years we are working for API. माझा API कसा वाढेल? And patent is very good to be considered in the API because one single international patent gives you 10 marks. And to get a 10 marks in a research paper, you need to have a very good impact factor journal. So patent is also good for the API. I am with 12 patents, so my API is already 120, and I am with patent only. My requirement of API is fulfilled. This point I included. This is not for the sorry. This is not for the entrepreneur. This is for the government staff like teachers like me. Why to go for patents? All of the time, समय की पुकार, समय की पुकार. Hereafter, I remember the days when I was doing MSc. Me, Sonawale sir, Subhash Donde sir, we were batchmate. When we were doing MSc, and when after that when we joined for the lecturership, we keep talking. I published 3 papers. I published 4 papers. अरे माझे बघ 2 पेपर आले. अरे माझे बघ गेल्या 2 वर्षामध्ये 3 पेपर आले. And then we were happy because that time publishing paper was a great thing. Nowadays the scenario has changed. My principal, my director is Dr. Naresh Chandra, who is the former vice chancellor, pro vice chancellor of Bombay University twice. He listened to the person with the paper, but he don't entertain them. He entertained the researcher with the patent. The time has changed. The time has changed. Even the research scholar, even the PhD student, when they sorry, if they apply the thesis, if they publish the thesis with the patent, the thesis got different weightage. In the beginning only, respected principal, Captain Pawar sir, former captain of my NCC, I am his assistant, I work with him, I am proud of him, proud of you sir. He said that China takes 21 months. That is good, really, really. India takes 41 months, good. Still, see how many patents they got in the China. Last year, around 15 to 16 lakhs patents were granted. In the USA, around 5.7 to 6 lakhs patents were granted in spite of the corona. In the Japan, around 3.5 lakhs patents were granted. And in India, in spite of 100 having population 1 crore 140 crores, only 29,000 patents were granted. And when I saw the PhDs awarded were around 21,000. So PhD 21,000 हो गया और patent 26,000 हो गए. India around 48,000 patents were applied, and this 4,600 figure is old figure. 29,000 patents were granted in the last year. You can see the last line. There is a large scope of research area for the patentability in India. That is why one should go for patenting. What is patent? See, the dictionary definition is given. We have already gone through the 2-3 seminars, and you must be knowing about. Patent is a legal document that is granted to the inventor by the patent office or control general of the patent, design and trademark. We have divided our speech into 3 criteria. I am here to make acquainted about the patentability. After me, Pooja madam is going to speak. Pooja madam has instrumental for around 5,000 different patents to be designed in last 2 years. And then Dr. Dinesh Wanule sir, another colleague, is going to speak about the legal aspect. Patent law 1970, patent कायदा 1970. This is the legal lecture. It sounds like tricky. It will be tricky, but you have to still study the patent law 1970. Once you study patent law 1970, it will be helpful for you to convert your research into patentability, into patenting. That is the important of that particular lecture. Convention application for patent made by virtue of section number 135. If you read the section number 135, it will help you how to fill the form number 1, how to fill the form number 2, how to fill form number 3, what is the important of form number 7, what is the important of form number 9, when to go for form number 15, how to reduce the time, At the same time, if you fill the form number 1 and then form number 3 and 4 for the for examination purpose, that all comes under section virtue of section of 135, on which Dinesh Wanule sir will going to speak as the third speaker. Patent will be granted only if satisfy the conditions of the patentability, and here be conceptual and clear. Decide yourself. I'll request you, instead of publishing 2 papers a year, publish 1 patent in 2 years. एका वर्षामध्ये 2 पेपर पब्लिश करण्यापेक्षा 2 वर्षामध्ये एकच पेटंट पब्लिश करा. The moment you publish the patent, the image in the society gets changed. I remember the first day when I published my 4 patents on the same day. How happy was me and my team and our director, Dr. Narendra sir. We are lagging behind. Again, I am telling you, we are lagging behind. How to patent it? Patentability, we don't know. We are very good in research. At any given time, Kamath madam is doing research. At any given time, Subhash Doongursee sir is doing research. At any given time, Sonali sir is doing research. Sir, where we are lagging behind, that we don't know how to fulfill in it all the research work for the virtue of clause number 135, and that is our need. Patent should be novelty. It's a dictionary term, novelty. What novelty should be there? What novelty should be there, and what type of novelties are accepted by the patent office? That is important. You do any type of research, you come with the design. You take it on the paper and you apply to the patent office. Patent office may reject it. The scientists sitting over there, they are PhD and they are LLM in their own subject. If you apply in organic chemistry with PhD in organic chemistry with LLM, if your application, you are applying the novelty in geography, and the patent officer is PhD in geography and he is LLM. So he knows the legal aspect and he knows the quality of research done by you. If your research fit in that particular novelty area, it is not repeated work, then only Government of India granted the patent. It should be non-obviousness. If it has industrial application, please see the clause has changed from last 1 year. If the patent has any industrial application, that is, if any industry approach you that your research we want, and they give a demand letter with your application number 1 of the clause number 135, the patent office take it at the priority basis. One more thing I can add here, respected all sisters. If there is one application where the industry is started by the entrepreneur, female entrepreneur, it is at most priority process in the patent office for last 1 year. They have changed the clause. So industry application, if there is an industry application, the patent granted time, if it is a design, has been reduced drastically. In-depth practical approach should be there. In-depth practical approach, that is what you do, practical approach in research methodology. You should have a clear knowledge of that. About this novelty, non-obviousness and industrial application, Pooja madam will going to speak in detail about this. Patent is needed because it will increase the public image of the department as well as with the institution. So now as I just told about that, I gave 25, around more than 25 keynote address in last 2 years. Before that, I was not known to the society. I was one of the teacher doing publishing research paper, writing books and all that. The moment I entered in the patentability in the patent field, people started recognizing me. This is not the case with me, but this is the case with all those who are involved in patenting. I'll be happy tomorrow. Kirti college student, Kamath madam is there, Donde sir is there, Kaude sir is there, sorry, Menon madam is there. It's very easy. You just read. You just need to read different patent and make acquainted yourself so that the image of the department and image of the institution will increase. Improve the quality of research in the department and institution. I visited UDCT. I visited IIT. I am happy that last year IIT Mumbai has been granted 86 patent in spite of Corona. And before that, the patent granted in IIT Mumbai just 1 year back was around 52. I'm in touch with many guides with them. They give the topic to the student like at the time of completion of the PhD or at the time before the completion of MSc master in that particular subject. The student will come out with the certificate of patent so that student can very well approach to the industry. It is improved quality of the research. Increase opportunity of the research funding. Good. But it's the same industry for who are working the research, for whom you are working for the problem. They only fund you. They only fund your student. They only fund for your student for PhD. Student is getting a job, entrepreneurship. The problems are solved. Sustained high scholarship level. This is for the students who are going in abroad. Please check the data. The New Zealand, the Canada, the UK, the USA. If the student is applying with the patent certificate, their entry fee, their course fee is being reduced to the half. Instead of crores, they spend in the form of lakhs. There are various hidden benefits from the patentability are available. That is why the patent is needed. Of course, not only to the society, even individual is also benefited. You own the invention for 20 plus years. You own the invention for 20 plus years. Minimum period is 15 years in Government of India. In foreign patent, it is around 15 to 20 years. You are the principal investigator, and you keep getting benefit of that. Student research scholars and guides mentor success and satisfaction. I told you, ultimately at the end of the day, with the money, so you are getting satisfaction. National international recognition. Yeah, it is there. It is there. The moment you come out with something good in the research, you get the recognition. This is for the startup in the Maharashtra. Uh, like you know about MIDC area, SSI small scale industry. I'm in touch with such people who have started their small scale industries. They apply for the industry, and then because their applications are with the supported documents, and one of the document is what type of what type of product they are coming out is already patented. It is easy for them to start up and to go for the marketing, royalty income. End of the day, we are here for the earning money, and royalty income is very good for that. I'm happy to share equal amount of my salary. I'm getting royalty because I sold my patent. This is the case with all those who are involved in patent and their patents are marketed. Industrial avenue, industrial consultancy, special consideration for CAF and API and PABS and whatnot. I remember when the NAC committee is there in my college, the first day, first visit there with the principal, and when principal highlights them about the strong points in the college, the NAC committee come to know the quality of research going on in their institution. In my Birla College, we are 4 to 5 teachers actively involved in patentability, and we are having around 50 to 55 patents, and year by year, month by month, the number is increasing. So management also happy, college is also happy, and we are also happy. Fastest processing for entrepreneur applications. Yeah, this last time I told you just few minutes back that Government of India Patent Office, there is another clause of fastest processing for entrepreneur application. If you apply for today and within few months you get patent granted if you are going for the production of that particular unit. Teachers and researchers, this is for the student who are doing post-graduation, who are doing MPhil, who are doing PhD. Please go for utility patent. Please go for utility patent. Please go for utility patent. Professor told that government takes around 41 months. Sir, it is true. Government takes 40 to 41 months to grant the utility patent. But utility patent got a good return. Not only monetary return, but even the society return. I told you last year, out of 29,000 patents granted by Government of India, very less, around 6,000 are utility patent, rest all are design patent. We need, our nation need maximum number of utility patents. The design patents can be a part of utility patent. Please see my statement carefully. Design patent can be a part of utility patent, but utility patent is real patent which help we to grow, which help our nation to grow. Number of patents in single product, that about these two line, Pooja madam will go that. See, should not go for improvement of existing patent. Please don't go. Please don't go. I am with the so many cases, like I gave you keynote address over here. I'm also consultant for the patent. I give free consultancy of the patent. I don't charge anything for the consultancy of the patent. You can approach me. And I know 80% of the patent which have been rejected by the patent office are trying to improve the existing patent. हरी भरी में जल्दी में चलो मेरे नाम पे 5 पेटेंट आ जाएंगे. We teachers apply for that and we don't go for the examination. We block them there itself, and if you go for the examination, they are rejected. So researcher should not go for improvement of the existing patent. The novelty concept gets hurt over here, and on that basis, the patent officer reject them. This questionnaire is very important. My invention, can I patent it? I invented this pen. मी हा पेन बनवलेला आहे. का मी याचं पेटंट बनवू शकतो? या पेनाची मी कॅप बनवलेली आहे, याची क्लिप मी बनवलेली आहे. काय मी पेटंट करू शकतो? करू शकतो. Yes, I can do it. I can patent it. Procedure. I am lagging behind the procedure. I don't know how to patent it, and there the legal charges for the consultancy are more. I know in the Mumbai there are consultants charging from 50,000 till 90,000 rupees only for this procedure, and it is very simple. You need to have a draft of around 250 words. Agent threat, it is there. You give to the agent, and then agent may copy from your material and may, yeah, please, I have no word. I don't comment on this thing. Cost of filing patent, how much I have to spend? Always this question is asked. In all this workshop, someone will ask this question that how much is money I have to spend? मला किती पैसे लागतील माझं पेटंट फाईल करायला? Dear friends, the cost is only 1,000 rupees for the application. It is very cheap to file a patent. It is very costly to prepare a patent. To have an invention is very costly. Identifying the clip of the pin is very costly. How it should be made, what length of the pin should be kept, how much is the gap should be kept, where to the thickness of the pocket, shirt pocket, how the locking arrangement should be made, how flexible the plastic should be, what type of advertisement it should be made on the clip. It should not touch to the finger. These all simple questions are involved in the research. Invention is very costly. After inventing, patenting is very cheap. I remember in 2016 when I applied for the first patent, the cost was 40,000, and now Modi sir has reduced the cost like anything, only 1,000 rupees. पेटंटच्या अर्जाची किंमत खूप कमी आहे. पेटंट बनवण्यासाठी जे संशोधन करायला लागतं, जे नॉव्हेल्टी लागते, त्याच्यामध्ये बौद्धिक आणि आर्थिक कॉस्ट खूप आहे. It is required for that. Time requires, patent needs patience. धीरे से करो. I told you, instead of publishing 2 papers a year, publish 1 patent in 2 years. धीरे से करो, शांति से करो. Take your own time. But once you apply it, it should be granted to you. Type of patents, there are 4 types. Pooja madam is going to talk in detail about the type of patent. Invention disclosure with whom? You should have a good patent agent for that. You should be having thorough knowledge of scientific approach as well as legal approach also. Please go for good scientific approach, good legal approach, and then you can very well convert your patent, your research into patent. This is what will guide you in today's speech. Hello. Let's start for the new beginning. Thank you, Donde sir.
Yeah. Thank you, sir.
Thank you, madam.
Yeah. Thank you, sir, for your informative session on legal dimension and publication of patent, especially utility patent. Now, may I invite Professor Page to introduce our speaker of the second session, Ms. Pooja Menon. Over to Page, ma'am.
Thank you, madam.
Thank you.
Good morning, everyone. Patents. This particular term entered in Indian houses with a pride when modern Haldighati Ladai was won by Dr. Raghunath Mashelkar through CSIR around 25 years ago against the US patent on turmeric. But as on today, when we talk about patents, there is very little information which we are having about it. So, we are going for the session Introduction to Patents in order to know the insights about the patents, and that too from an expert, Ms. Pooja Menon, COO from Microwave Consultancy and Services, Vadodara. The Microwave team has conducted more than 1,800 seminars addressing 45,000 students, and more importantly, have successfully filed 5,500 IPRs with educational institutes and industries. So, this is basically going to be the Microwave team, and today we are going to listen on patents from the COO of this Microwave team, Pooja Menon. Pooja madam has done her BTech in Information and Technology and is also having the diploma in Intellectual Property Rights. In addition, she is having the certification in IPR from the Rajiv Gandhi National Institute of Intellectual Property Management. She is having the industrial experience of 8 years, and I'm sure with this introduction, We all are eager to listen to our expert. So over to you, Pooja ma'am. Thank you.
Thank you, ma'am, for the warm welcome and thank you for the introduction. I'll be just sharing my screen so we can just begin with the session. Ma'am, is my screen visible?
Yes, madam.
Yes, ma'am. Your screen is visible.
Okay. So a very good morning to all of you. I think today in the beginning we have already been introduced to what IPR is, what patenting is, and we had a very brief discussion. See, this word has entered our life since last few years and it has been used very frequently now. But the problem is because the knowledge which is being imparted is incomplete or maybe in a very complex language, there is a lot of confusion still in the market regarding what patenting is, what copyright is, what trademark is, what design is. I know that all these four categories you might have heard these words very frequently, right? If people talk about innovation, if people talk about artistic work, or if people are talking about branding, these words have been used very frequently, and the current government has been doing a lot, has been providing everyone with a lot of facilities to make the filing much more simpler. Okay, so like in the best example is that in the last few months the government fees of an educational institute has been brought down to almost the fees of a natural person. First, and means the fees has already almost reduced to 1/5 of what it was in the previous few years. They just want to promote the educational institute to file more of IPR, in respect of patent, copyright, and trademark. So in today's session, we'll be focusing on in my portion of session, we'll be focusing on two things. See, you're going to invest 1 hour of your time into my session, right? So you need to know कि आप इसमें से क्या ले जाओगे, right? If you're giving your time to anyone, you need to think कि मुझे क्या benefit होगा, right? So in today's session we'll be seeing to it कि आपको as a individual, as a student, as a faculty, as an institute, IPR आपको किस तरीके से एक प्रोग्रेसिव पाथ पे ले जा सकता है, हाउ इट कैन हेल्प यू टू गेट अ बेटर बिल्ड अ बेटर पोर्टफोलियो, or maybe to get a higher ranking in accreditations, maybe to get a better job, or to get better scholarships if you're pursuing further education. So all these things are very easily possible with IPR services. So let's begin. Basically, there are two types of property. As principal sir was discussing, one is called the physical property and other is called the intellectual property. अब physical property हम सबको बहुत अच्छे से पता है. Like in your day-to-day life, if you want to, show off yourself, so you'll be like, you know what, I've got money. I've got a big house. I've got land. I've got a big car. So much gold in my property. We have been taught from a very young age that if you want to show off, or if you want to boost, or if you want to stay secure in your life, you need to have physical property, right? And we know that to buy a physical property, you need to be hardworking. If you are a good person, you need to be hardworking and earn a lot of money to build a physical property. And we are very much we are taught that we should be able to protect our physical property. Now suppose if I come to your place to have a cup of coffee and I'm like, you know what, let's do one thing. So I love your place, so you can just pack up your bags and leave. From now on, I'll own this place and I'll stay here. Can I do that? Will you allow me to just intrude into your place and just ask you to get out of your place? No, you will actually push me out, maybe get a stick to drive me away. You can do that because you own the property. You have official government property papers. घर के दस्तावेज होंगे आपके पास जिससे आप ये prove कर सकते हो. You can prove that the house is yours, right? So that is the surety which government registration provides you, such that nobody else can just trespass into your place. Now let's talk about intellectual property. See, we are very careful when it comes to our physical property. We get it registered even before endorsing it to our dear loved ones. We'll see to it that we have a government proof that the property is ours, right? But let's talk about intellectual property, which means your ideas, thoughts, research, projects, papers, anything that is done in the creative sector is called intellectual property. Intellectual property means something that does not currently exist in physical form, but it is in your mind, okay? You just thought of something, and that is called intellectual property. Now, we are very careless when it comes to our intellectual property. Imagine you're working on a research and suddenly you have a eureka moment. You're like, oh my God, if I do it this way, this has never been this is an unexplored path, and this can, do miracles. This can bring a progressive thing into something. Okay. So see, whenever you have such a realization in your research sector, as a normal person, everyone has this mentality. They'll either give a call to an intellectual friend, or maybe talk to a colleague, or maybe a person superior to him or her, and they start discussing the idea, right? See, understand, in this entire world, everything is a competition. Whoever you're currently with, working with, everything is a competition. Everyone wants to have fame or money, right? So imagine you discussed this content with somebody who is equally intellectually competitive to you, and he or she decided to publish the article in his or her name, even without adding you as a co-author or whatever. Okay. Now, do you have any proof or right to stop that person from doing that? Or just to claim that, the idea was yours and you found this while during your research? Basically, no. See, you cannot just stand on a property and say, Aaj se ye ghar mera. You cannot do that. You need a proof to show that, yes, this property is mine. Similar is the case when it comes to intellectual property. And intellectual property has a shelf life of a banana. So if you put it out there, it's very much, there is a big chance that it will get rot like this. So do not risk it. How can you do that? Government has a provision called intellectual property rights, where you can apply for an idea in mere minutes, just minutes, before even start, even before you start discussing it with someone. All these things needs to be protected, and that is why government has provided you with 4 provisions: patent, design, copyright, and trademark. And all these 4 secures different types of IPR. And today I'll be just briefing you about what all things are secured under it, how you as an individual can play a big role, how you can protect few things. See, I know that maybe patent is bought into a bigger hype these days because it carries a lot of commercial value. But understand, every IPR has individual value. So in today's session, we'll be addressing and we'll be learning how you as an individual, for all the work that you have done, you can relate yourself with different IPRs. Okay. So let's begin. The first topic that we are discussing is copyrights. Copyrights is very simple, and it talks about securing the rights of an author. That means all the work that you considered as artistic or an expression of a content can be protected under copyright. So see, for us, maybe the music industry or the film industry may be not of much importance. We just get entertained once a week. But there is a huge population that earns from copyright, right? So every music, software, presentations, plays, books, movies, recordings, photography can be protected by copyright. Now, whenever I start talking about copyright, people are like, you know what? This is the generation of social media. So what if I write a content and publish it online? See, I wrote an article on something and I just publish it on the website. So people will already know that the work was mine, right? Understand, whenever you decide to publish a work, it means the timestamp is shown, right? That timestamp shows the date of publication. It does not prove that the work was done by you, or you did this work on so and so date. Okay, so there is no what do you call, official documentation regarding the ownership of work or the date of creation. On the other hand, when you file for a copyright, it provides you with a time-stamped, government sealed proof of document which claims that you are the owner of the content and you have rights from so and so date. The date of application, the date on which you apply for a copyright, is the date of creation of the work. So that is why IPR is always first come, first serve. The first person to apply will have the ownership of it. Okay, so if I read an article online, I just publish it onto my wall, it will never mean that I wrote it. But if I apply for a copyright, it means I am the creator of the content. So that is the difference between a copyright and a general publication. Now, where does this have the importance in a normal life? Okay, see, I don't create movies, maybe I don't write poetries or something like that, but I'm in the sector of education, I'm in the sector of academia, right? I do research work. Like me, you all are involved in research, and you have been writing papers, you have been creating presentations, you have been creating lecture notes, right? All these things are also protected under copyright. Understand the importance. Suppose you wrote a paper and you approached a publication house to get your paper published. You might have noticed that they always share a TNC page with you, which you usually sign and send it back. Have you ever read the clause carefully? So there is an IPR clause which states that the content which is being submitted to the publication house is now on the ownership of the publication house. Okay, so we have the right to use, misuse, translate, publish wherever we seek necessary, and you as an author cannot stop us from doing the same. Layman language में समझिए. Suppose you had a house, okay, and suppose you have a house and you're not staying there, okay, and you want to just rent it out or lease it out to somebody. So instead of signing a lease agreement, you decided to sign a transfer agreement even without charging anything. Will you be ever so careless about your physical property? No, we won't give any of our physical property free of cost, right? If we have a property paper, we'll read it 10 times, get it validated by 10 others, and then we'll sign the document. But here, the paper presentations, the paper publication house, the paper that took you more than 3 months to draft, even without thinking once, because you wanted the paper to be published so desperately that you did not even see the terms and conditions, and you gave the entire ownership to a publication house. Now, when they will apply for a copyright, which they do, they will apply it as a owner of the work and not as a publisher. So what should you have done? So you should first apply for a copyright and give only the publication rights to the copyright to the publication house. When they will reapply as a publisher and not as a owner of work. This will help you when you decide to write a book on this and use the same content. If you don't have the copyrights of it, you will not be allowed to use the same content in your book. Every lecture note that you prepare, every presentation that you prepare, everything written, artistic work, dramatic work, software, video, audios, everything that you create in the educational sector can be applied for a copyright. Okay. Now let's take an example to understand the importance. Suppose you are planning to work with a company, okay? How copyright infringement can be a serious problem. Understand? See, if you decide to open your own company, or maybe you decide to work with a company or any institute which enters commercial field. See, when you're in the educational sector as a teacher, as a student, you can use any of the IPR free of cost, because you are in the sector of education, and IPR rules are quite bendable when it comes to that matter. Government states that if anything is used for educating a person, it cannot fall into what do you call infringement. But if you're using any content and you're earning money out of it, it's in the commercial market helping you to earn money or fame, it is a big case of infringement. Okay. Okay, so here is an example of how if you are working and entering a commercial field, copyright infringement can be of a bigger issue. Now, we all know the company Tata Consultancy, right? We all have heard about TCS. Now, Epic System is a software manufacturing company in USA. So they develop softwares for different companies, and they develop the software for hospital chains, and they hired TCS to do all the maintenance work. Now, it is a very common trend by all the international companies. They develop the software, get it installed, and then they hire third-party company for maintenance work. It is cost effective for them, right? So now what happened was TCS was hired to do all the maintenance and database management and all such stuff. When a third-party company is hired to do all these maintenance work, they sign a confidentiality agreement. The people at the managerial level usually signs these things. So when they sign the agreement, they have a confidentiality clause which clearly states that we will be sharing our data, clients' data, and confidential data with you for the business purposes. You are not allowed to use, misuse, or breach any data in any form. If found, you will be liable to whatever injunctive relief we feel feasible. So what happened was the contract was signed, but the people who came to work on the software were at the technical people, right? The software developers and all those people who were not aware about the confidentiality agreement. Believe me, I have been in the R&D industry for the starting 2 years of my life, and I know the culture what here the people in India follow. Nobody is aware about any legal consequences, because usually you are first college pass out, or maybe you're entering the industry for the first time, and you are at a level where you are not made aware of all the terms and agreement that is being signed by the company. So you just work whatever you're told to work in. So the people who came to work on Epic Systems software were not made aware about what are the consequences that can occur if you breach anything. So the guy who was working on the back end, he loved the software. He came back to India and suggested to develop a similar software here in India. And they developed a software called MedMantra for the hospital chains here in India. Epic Systems came to know about it, and they were so furious that they slapped TCS with an infringement compensation for an amount of $940 million. So see, the infringement was caused by the employee of the company who was not aware about the confidentiality agreement. But at the end of the day, TCS decided to publish that, to use that created software in the commercial platform. Epic System was liable of, all the compensations, and TCS as a company had to pay for the losses that has been created. So you need to be very careful. Whatever data you're using, if it is going to be on any of the platform or maybe in a commercial way. Example, you're writing an article, right? And you find somebody's content from a different book important. You cannot just say that I'm just taking a reference into my book. You will have to inform that person that look, your study is being going to be published into my book as a reference. Do you mind or not? You cannot start printing a book without taking permission, because when you're taking a reference from somebody's book, if you're using the exact written content from his book, it's a violation. Do you know, in India, if you're unable to pay the compensation amount, you can be put into jail for a term of 7 years. So do not take copyright infringement lightly. Okay, so they are allowed to ask you for any compensation that they feel is important. Over and above, they can even put you in jail. So do not take copyright infringement lightly. Okay. So here we have put together a few questions which we usually get from the crowd, just to make this topic much more understandable. So what does copyright actually protect? So copyright does not protect the idea. Please understand, आप जो idea create कर रहे हैं उससे protect नहीं कर रहा, वो उसके expression को protect कर रहा है कि आप वो content को किस तरीके से portray कर रहे हैं. See, the best example is there are so many movies that have their what do you call, concept of love story, or maybe an alien invasion. So the idea of alien invasion or a love story is generic. So copyright does not protect the idea, it protects the way that a person, that the artistic person, the director, or the screenwriter is expressing the love story or the alien invasion. Okay, so the way in which a content is being presented is what is protected under copyright. Okay. Is it necessary to register a work to claim copyrights? See, if you want to claim rights with evidence, copyright filing is mandatory. Otherwise, you will just be screaming at the top of your volume with no proof. Where can I file the application for registration of copyright? So in India, there is just one copyright office, that is in Delhi. So you do not have to travel. The entire facility is available online. You can just log into copyright.gov.in and you can file your own copyright. Okay. Can I myself file an application? Yes, you do not need a lawyer to file a copyright. You can actually create your own account and file for a copyright. See, a lawyer, an agent, they are only required, or you need their assistance only if you're not sure about the data. See, what happens is there are some legal terms and conditions which needs to be fulfilled. And when you file it, there is 100% chance that there can be error. But if you're very confident about it, that you can understand, you should file it on your own to avoid the agent fees or the attorney fees. But otherwise, the help is needed only to address all the legal issues that can be raised by the registry. Otherwise, every IPR filing can be done by oneself. Okay. Whether unpublished works are registered? Yes, we will always suggest that the copyright or any of the IPR should be filed before publishing the data to protect the novelty of the concept. Okay, so we'll always suggest that file a copyright before even publishing it anywhere, to protect the idea, to protect the novelty, to protect the content of whatever you have written. So I hope copyright is quite clear. Like towards the end of this session, we'll be having the Q&A to address each of your queries, or you can just put it into the chat box. So during the further session, I'll be addressing each of the query one by one. Okay, so the next topic that we are discussing is trademark. Trademark, I'll take it very short because this is related to branding. It is not more inclined towards academia, but you should know about what is trademark and what is the difference between TM and R. Okay, so understand, if you want to recognize a product, or you want to visit a place, or you want to buy a thing, you need to know that the product is authentic or the place is authentic, and that is only possible with trademark filing. Trademark assures that the brand is officially registered by the registry, okay, by the original owner. So trademark protects the identity of a brand. Like for example, how do you recognize a product? Using its name, logos, symbols, taglines, jingles. These things provide identity to a product. Like suppose if I'm driving from say Himachal to Maharashtra, okay, so if I'm driving and if I'm hungry, I will definitely look forward that I eat at a food chain, right? Whether it is McDonald's or something. Like if I see a yellow capital M, I know the food is not that good to eat every day, but at least when I'm traveling, I'll trust a food chain because I know that it will stay constant all across the world, right? So I prefer that I eat in a food chain. So that yellow capital M is the official trademark of McDonald's, and nobody else can use a yellow M in the industry of food, okay? Because that is a trademark violation. So with the trademark filing, the identity of the product or the brand is protected. Okay, there are a few more things that are trademark, like sound, smell, voice, dialogue, three-dimensional design. Understand why? Suppose if I'm buying what do you call a perfume, okay, I'll see to it that not just the brand name but the smell is also tested. If I am putting in $1,000 for a perfume, I need to know that it smells good on me, right? So every perfume manufacturing company will see to it that the smell, the authentic smell, is protected under trademark. Okay, so talking about sound or voice, when we were kids we used to watch Tom and Jerry, right? So even today we watch Tom and Jerry. I'm still a kid at heart. Okay, so in the beginning of the cartoon, there is a lion roaring. That sound is so nostalgic that even if when the sound is played today in any of the movies, I'll think about my good childhood, right? You come from your school and you just plug in, switch on the TV, and your mother is feeding, right? So feeding you food. So that's a memory that sound has created to you. And that sound is the official trademark of Walt Disney. And without their permission, nobody can use it. Even today, the Warner Brothers movies, Warner Bros movies start with this sound. It gives you a thought that now you're going to have a great experience. Now you're going to enter a great experience with this movie. And that is the vibration which is protected by these companies. Okay. In India, what do you call Amitabh Bachchanji's voice, Sunny Deol's voice is trademark protected, and few celebrities even trademark their own name. Okay, like Sachin Tendulkar has his brand, his name protected. SRK has his initials, SRK protected. Now they are celebrity. Their name has a brand value, right? So if they come on screen selling water purifiers and houses, you will definitely look forward because they have a trust identity, right? You might have remembered that when Amitabh Bachchan was endorsing Maggie, and suddenly, Maggie was identified with lead poisoning. He actually quit. He actually quit the advertisement because his name was getting violated with a product that is causing you poisoning. So that is how the brands, the identity of these celebrities are of importance. They need to see that their name is getting linked with good products. And how do you see that? That is only possible with trademark filing. They protect their name such that their name is not violated or used by anybody just to be in the market. But what as an individual can you do, right? What can I trademark? I'm not a celebrity. I don't own a picture or a movie name. But if I create a website, I write a book, I start a blog, or maybe I design a software, I have an educational institute or I start any coaching institute, I can trademark the name of it. So as an individual, I can protect what I create, right? Like if you write a book today and you can name it, like I can name it Pooja ki Atmakatha and have a trademark on it. I can apply for a trademark, but government will decide whether to approve that name or not. Like for example, you might have seen the symbol TM or R. Now let me make you understand the difference between the both. When you apply for a trademark, you're allowed to put TM. Now, TM does not mean trademark. It means temporary mark. That means you're going to let the people in the market know that the trademark has been applied and the government is doing the examination whether to approve the brand name or not. Okay. So once the brand name is approved, you can change the TM into R. That is registered trademark. And that means nationwide, all over India, nobody else can use the same brand name in the service that you're providing. In the layman language, let's understand it better. Suppose you get engaged to someone. तो आप मार्केट में ऐसा एंडोर्स कर सकते हो कि ये मेरा बंदा है, ये मेरी बंदी है. But there is no confirmation that the engagement will get progressed into marriage. कई बार ऐसा होता है कि engagement टूट जाती है. So yeah, you can flaunt to people that I'm engaged to her, I'm engaged to him, ये मेरा बंदा है, ये मेरी बंदी है. But there is no 100% assurity कि वो आपका ही बंदा रहेगा. But once you're married, everything is legal, right? So TM and R is like that. TM is like the engagement where you can tell people that it's your brand, but once you get married, it is R. So once it is registered, it's R, and then everything is legal for you. Okay, then nobody else can touch your brand because वो आपका ही है. Okay, so I hope trademark is quite clear to you and copyright is quite clear to you. Now we'll move on to the third topic, that is patent filing, which you all have been very eager of. Now there are very minute things, very small myth that has been in the market for so long, because see, till now, the people in the legal sector have been involved in the patent filing, and the patent filing were done by the large industrialists, right? Till date, the individual filings or the institutes being involved in this sector was very less. Even if you are intellectually brilliant, the people who were involved in this field were purely lawyers. Okay, so what happened is this business was fear business. जब तक मैं डर नहीं फैलाऊंगी ना, तब तक business नहीं होता. So that is why there are so many myths that was built into this market, which we'll be resolving today. So let's start with what is patent. Now, as I told you, copyright protects the expression of work. It can be logical or it can be illogical. Like suppose if I do a painting and I paint sun pink, practically you will say कोई logic नहीं बनता. But understand, it's an artistic liberty. I can paint sun pink and nobody is going to come and question me. I'm the painter, I can do whatever I want. But when you talk about patent, we talk about ideas, innovations, methods, process, mechanism, and everything needs to have a logical information, logical explanation. I cannot just say, hey, I have got a powder, I can make a person invisible. Government will ask you how. And you cannot say, I have got magical powers. If you have got magical powers, write a book, file for a copyright, okay? Because it can protect the artistic liberty. But when you talk about patent, you need to explain to the government why you're doing it, what is the advantage, and how you're going to do it. If you do not know the answer to how, even theoretically, you cannot apply for a patent, okay? So it has been categorized into three categories. One is called the utility patent, that is process, method, machine, manufacturing. Second is called the design patent, and third is genomically engineered biotechnology based patents. Okay, now the biotechnology patent is a utility patent, but let me explain you the difference between all the three. When we talk about the first, the utility patent, in the concept of patent filing, you do not need a product to file for a patent. That is the first myth. People usually start कि product होना जरूरी है तो ही आप patent file करेंगे. Please understand, when do you file a patent? You file a patent when you have an idea. And why? Such that when you start discussing it with people, you are not in the constant fear that ये copy कर लेगा, या ये copy कर लेगी, ये publish कर देगा, ये publish कर देगी. You don't have the fear when you start discussing the idea, right? So that is the stage where you file for a patent. What do you think, that Apple with the 3 years, 4 years R&D and then they file for a patent? No, they file a patent when they have an idea and they have a clear view of what they want to develop. Once they have a theoretical explanation, they'll file for a patent and then they start the manufacturing or the first prototyping of the product. Okay, so when you're filing for a utility method patent, you do not need any form of product. Okay, now let's understand the difference between utility and design. Suppose this is a cup. Okay, now what is a cup used for? If I want to drink a hot or cold beverage, I can use a cup. So there are multiple companies which manufactures a cup. Suppose I'm an adult, so I can hold the cup very comfortably and have a sip of whatever I want. But understand, if there is a toddler, maybe if a kid of age maybe 3 or 4, if you give him or her a big cup, they are 100% going to spill because they'll fill it till the top. बहुत जरूरी होता है कि ऊपर तक भरे, and it is very difficult for them to balance the cup in their small hands. So they are definitely going to spill. But there is a brilliant person who decided to give it one more handle. Okay, so with that second handle, the child can grip it from both the ends, and now he or she can drink the whatever beverage is in the cup very comfortably. So when I change only the design structure of a cup without changing any features or utilizations or method, it is called a design patent. When I'm just changing the way a product looks with the importance or enhancement, it is called a design patent. But on the other hand, let's talk about utility. Here, I'll need to change some features into it. Now, for example, I am a person who loves to have a frothed coffee in the morning, and I do not have a frothing machine. Okay, so how does a normal person make a frothed coffee? Okay, so you put in some coffee powder, sugar, a bit of water, and start beating the coffee. So a good beaten coffee gives you a good frothed coffee, right? But imagine waking up at 5 in the morning and start to beat the coffee. It's a very hectic job. Okay, I'm not that lazy, but yeah, 5 o'clock in the morning beating the coffee is lazy. But I'm a science person, so what I do is I make an arrangement where a small motor or rotating thing is available, a switch is available, and a small rod is available. Now, when I switch on the button, the the rod will start whipping the content in the cup. Okay, it will start beating at a frequency that is arranged by me on the system. Now my cup is an automatic frothing cup. I gave this cup additional components, additional feature to make a problem that I face every day in my life simpler. Now, once the entire coffee powder is beaten, now I just have to pour in my good cup of hot or cold milk and I can have a good cup of coffee every day in the morning. So I found a solution to my problem by giving my cup additional features, making it an enhanced design. So when I enhance the working components method working, it is called a utility patent. Now, talking about the third type, if you're working with plants, animals, the microorganisms, it's called a biotechnology based patent. In that case, if you're working with microorganism, the sample submission is mandatory. If you're working with DNAs or if you're working with hybridization or something like that, the sample on which you worked is mandatory. Okay, so that is where the patents get separated. But if you have used plant extracts or some extracts to help the animals, in that case, there is an NBA certificate, that is National Biodiversity Certificate, which needs to be submitted to the registry that this is the plant which has been used in the experimentation. That is the only thing needed. Apart from that, the utility patent and biotechnology based patent is similar. Okay, there is an entire document drafting which needs to be submitted. But when it comes to design patent, only the 7 views of a design is required for the filing. Apart from that, a design patent can get granted within 3 months to 12 months. And the fastest which we have seen is 4 weeks. So within a 4 weeks, you can be a patent owner in India. Because now the government registry has made the filing and registration procedure faster for all the Indian people. Okay. Apart from that, I know this might sound biased, but if you are a if your entire application has a female applicant, in case of a utility patent, you can even have a utility, a method patent granted within a term of 12 months. I know it might sound a bit biased, but it is just to you can get a female applicant in your application. So just add a female applicant and you can have the entire procedure fast forwarded well, basically the utility patent takes around 2.5 to 3 years. That is the reason why people avoided, to file a utility patent. But now you can have it within 12 months. And as an educational institute, you can always speed fast your profile. You do not need any other, specification. You're an educational institute, you can take the liberty of, have an express examination. Okay. One of my favorite facts. In the world, 90% of patent is filed on improvements. That means a patent has already, like a product is already available in the market. Like you have already seen that, okay, this is the product. But looking at the product, you feel that maza nahi hai. Let's make some changes into it. Maybe a feature, maybe a look and feel of it. And when you decide to make changes into the look and feel of a product, it can be filed under patent. What government states is that 1% improvement is what is required for filing a patent. 1% existing product, 1% you make the change and you can apply for a utility patent or a design patent. Okay. Now this is one of the very good examples. Gramophone existed, and then there, to listen to music, old movies and, kings and queens had gramophones, right? Then there came a generation where tape recorders were used, cassette players, right? There came a time where CD players were being used. There were multiple CDs for everything, for movies and songs and everything. Then there came a generation of Walkmans, right? Then iPods. Now your mobile phone does everything that you want in your day-to-day life, right? When you talk about electronics. But somebody, when the gramophone, tape recorder and CD player existed, somebody thought that if I want to walk on the street and listen to music, it is practically not possible, right? I need something, because imagine carrying a tape recorder in your hand to listen to music. And tape recorders usually does not work on batteries, right? They have to be connected to an electric wire. So not possible. Somebody came up with a concept of Walkman. So somebody customized that heavy music system into something very small that can be handy. Similar is everything around you. We are currently in the decade, in the generation where everything from last 20 to 30 decades, 20 to 30 years have been modified, customized, shrinked to a size which is very easy to use. Imagine in the 90s, we had landline phones. Do you know the pain of landline phones? If your best friend calls, you cannot talk, you cannot gossip, okay? Because your parents will be nearby and you cannot take the phone outside, okay? So you have to stand there and think about passwords and, code words to talk to your best friend. Very painful. Second came the time of cordless phones. Yeah, thank God you can at least take the phone and move to the next room. But still, you have to talk when you're at your home, right? Then there came a time of keypad-based mobile phones. Now that is the best time. I know today smartphone users will say कि अभी का better है, but the keypad phones were very handy and nobody knew that you were texting when you were in the classroom. That was the best time. It was a good time. Then now is the generation of smartphones. Every one of you today in this session has a smartphone with different features, different cameras, different music, sound, display, shapes and size and everything. When one feature is changed in any of the apparatus, that is applied for a patent. Okay, so you just need to think what is possible. Talking about big things, even very small things are patented. The best example is everything that you touch from morning till night is patented. The brush that you hold, right? The toothbrush that you hold is patented. हमारे लिए उसकी importance कितनी है? 2 minutes twice a day. But every company who manufactures any product that is put forth into the customer service is applied for the patent. The water bottles that you use, Milton Company has hundreds of patents. Do you know the company Gillette? Now we all know Gillette, right? If you are a male, you definitely know it. And if you're a female, you'll definitely have a male in your life that will be using Gillette Company, whether it's your brother or father or husband or whoever it is. They are a company who just manufactures razors. Their 72% asset value is IPR. That company has a 72% asset value, which is received from all the patents and trademarks and copyright that they own. So now you will understand the value of IPR. Okay. Now here I've just taken an example of a big company like Apple to make you understand how to look at a perspective of need to file a patent and how utility patent and design patent can be obtained from a single project. Now here, Apple company had a group discussion and they were like, we are going to come into a generation of bendable mobile phones. We all know that our normal phones cannot bend or fold or anything like that. But now the phones are going to be flexible. They're going to flex and move. It's going to be very stylish. So they are like the patent of a flexible mobile phone is with different companies like Apple or sorry, like LG and all. So what can we do to be in the market when these company will launch the bendable phones? So a genius person told that let's manufacture bendable mobile covers. Understand the logic. Now this is a mobile cover of a normal mobile phone. Okay? So if I use this mobile cover for a bendable phone, it will not bend. This is plastic, so it will not bend. Okay. Other is the rubber mobile covers that you use. Try bending it. If you try bending it, it will start bulging out from the sides or from the back. It will not bend and flex as per your mobile phone's flexibility. Imagine you have a 75,000 to 1 lakh worth phone in your hand and a bad mobile cover. See, mobile are a style statement. You will not do that. We might buy one mobile phone a year or like in within 2 years, but we might buy a mobile cover every week or twice a week, right? So we change mobile cover more than we change mobile phones. So we want it as per the mobile's feature or look and feel. So they came up with a material to create the mobile cover, which can stay attached to the electronic device and it can bend and adjust itself as per the movement of the phone without bulging or stretching from any of its sides. So that material and the making of the mobile cover was applied for a utility patent. And the structure which was adapted for the electronic device was applied for a design patent. So now you understand, just look at the problem. And if the problem already has solution, see what the other problem that solution can provide. I love the pharma industry. They create a medicine to solve a problem, and then the side effects of the problem is provided with another solution. So that is how the entire IPR industry work. Create a problem and then find a solution. Create mobile phones, create addiction, then build a system to solve the addiction problem. So that is how you need to think. If you want to be an innovator in your sector, find a solution to an existing problem, and you can be a patent owner even if you do not have the product live in front of you. Okay. Apple company, in a single Apple phone, there are 200 patents. See, Apple is not just a company, not just expensive because it's a huge brand. It is a huge brand because it has IPR with it. They are a very innovative set of people who look for that everything is the best and everything is unique. Nothing is copied. Okay, so they are very competitive people. That is why they are a huge brand. Now, talking about patents, the other myth is like, you need to be a researcher, you need to have a lot of qualification to file a patent. No. India's youngest patent holder was only 9 years when he filed for his first patent. He was, by the age of 14, he had more than 10 patents. We sadly lost Hrideshwar Bhatti in the COVID. Actually, he couldn't walk. Actually, he had few of physical problems, but he was a innovative set of person. Okay, he saw what is needed in the day-to-day life and created something innovative. He even had a patent on the wheelchair because he was a frequent user of it. Because he couldn't walk, he was always in the wheelchair, and he found so much problem in it that he filed multiple patents on his mere wheelchair. So that is how innovation strikes you. You do not need a qualification. There is no age bar restriction. Just an innovative mindset can help you to file multiple patents. Okay. So talking about patents, as I told you, you do not need a prototype to file for a patent. Vernetex is a company which is the best example of it. Now, Vernetex is a company with 15 people. What they do is they sit in a big gigantic office and look forth to what our technologies are upcoming. Then they file different patents in that sector, just file, not a single product. And then they license the idea or in the upcoming technology to big companies like Microsoft, Facebook, Apple, and all. So once you have the idea with you, the other companies cannot manufacture at least for the term of 20 years. So what you did is you restricted the idea. Now you will let other people invest into R&D, let them manufacture, and you earn money for licensing the idea. We have so many such companies in USA, and now it's the time where India takes it up. Okay, we do not need a product to file a patent. Just think in the sector. Okay, you have been dealing with so many projects, research in day-to-day life. You have been using so many apparatus to analyze different products. Think where the innovation is required and you can apply for a patent. Okay, we have arranged few Q&A just to make the topic much more simpler. Can an invention be patented after publication or display of the public display in the public exhibition? No. See, this is one of the biggest mistake we Indians have been doing for generations, and why we have the least number of patent till date. Because we all are into social service. We believe that whatever research is done is for public benefit. True. But what happens is the idea's novelty, the uniqueness of a content is lost as soon as it is published. But if you want to file for a patent, it has to be filed before it is published. Okay, so do not make the novelty get lost because you decided to file a paper. If you want to do social service, great, but file a patent and then publish your work. Okay, such that the count is shown, and if somebody a person tries to violate or use your apparatus for something wrong, you can at least stop that person from doing so. Okay. In which language can patent application be submitted? In India, two languages are permitted, Hindi and English. Jurisdiction for filing patent in India? Yes. India has 4 patent offices: Mumbai, Chennai, Kolkata and Delhi. And every state has been defined that under which jurisdiction they can file. Like if you're a person from Maharashtra or Gujarat or Madhya Pradesh or Chhattisgarh, you can file it in Mumbai office. If you're from North, may say you're from Uttar Pradesh or Delhi or Haryana, then you'll file it in the Delhi office. If you're from the south, you'll file in Chennai, and if you're from the east, like West Bengal or Sikkim, you'll file in the Kolkata office. Okay, so that is how everything is divided, just to make the examination much more simpler. Okay. What is the term of a patent? If you're filing for a utility patent, the term is 20 years. If you're filing for a design patent, the term is 15 years. Does Indian patent give protection worldwide? Now, this is the second question which usually comes up to us. There is nothing like international patent. ऐसा कोई scheme ही नहीं है. When you apply for a patent in one country, you get the patent rights in that country. Like suppose if I file a patent in India, nobody else can manufacture or sell from outside into India. Okay, I restrict all forms of manufacturing, use or reuse in my country. Okay, but if somebody wants to manufacture it in China and sell it in Sri Lanka, I cannot stop them. To do that, I'll have to file a patent in China and Sri Lanka using the PCT services. That is, yes, international filing is possible, but you have to apply for a PCT, Patent Cooperation Treaty, which is a provision to file patent in different countries. You will have to pay the government fees of individual countries and get the process started. Okay, but understand, a patent can only be filed once. आइडिया एक ही बार क्रिएट हो सकता है. अगर आपने आइडिया इंडिया में क्रिएट किया है, वर्ल्ड में कोई दूसरे कॉर्नर पे नहीं बोल सकता, ओ उसने इंडिया में क्रिएट किया, मैं यूएस में क्रिएट कर रहा हूं. नो, the birth of child can happen only once, right? If you're born in India, you're born everywhere in the world, right? So ऐसे तो नहीं बोल सकते हो ये इंडिया में born हुआ है तो अब यूएस में आके इसको कुछ और करना पड़ेगा. No, it's not possible. So the birth of an idea can happen only once. So whether you are filed in India or US, the idea has already been in the public by you, so you will be called as the owner of the idea. Okay. Now, how we as a team can help you? Okay. So see, as Nagre sir has already informed, this is not just about informing you about what patent is. This is about how we can help you as a team to bring the patent out of you. See, there is so much research happening. In the last 8 years of my experience, I have seen so many ideas which have just gone into like just in paper publications. People have decided to publish papers because they never knew about patent. The unawareness has created us so much loss that nothing else can do. See, the problem is when you do a research, you are an intellectual person and you will just look for ki research se output aaye. But we as an IPR team will help you to find the novelty into it. We'll help you to identify what can be picked out of your project and applied for a patent. Or if that is already published, how can we enhance the features to the next level, futuristic purpose, and apply for a patent? Okay. So by filing the patent, it can happen as an individual or as an educational institute. But we'll always suggest that because you're a part of an educational institute who has provided you with a platform, an IP cell establishment can help with multiple filings. with enhanced virtual R&D. We can have expert visit to have a one-to-one discussion, which can help to bring out more novel ideas in way of utility and design for the educational institute. Okay, so this is few examples which we have worked on in different sectors, which will help you to identify that how research can be helped, you know. So now what happened was, we had a person from the sector of I think biology, and he was like, you know what, the people in up north where it is very cold and the electricity does not reach, the IV fluid, to heat the IV fluid in hospitals, it's very difficult. So if you don't have electricity, or if you don't have a heating chamber or something like that, or the facility, the IV fluid, you know, the fluid that is injected into a human body, like maybe blood or glucose or something like that, which is preserved, it is freezed, needs to be heated to a normal temperature, a body temperature, before it is fed into your body. Otherwise, the person will have a heart attack. Okay, so basically, I as an engineer was not aware of it. So, but the person in your sector, maybe biology or zoology, is quite aware that how the system of heating of the process takes place. So what our team suggested was, we as a group of engineers, or we as a group of science people, collaborated with this guy who was a genius scientist, and we came up with a solution. We created a chamber which had nanomaterial on it. Now nanomaterials can be agitated, you know, you can make the nanomolecules vibrate to produce heat by just using light. Now light, the intensity of light can be controlled, and the light can be, you know, used provided using batteries, so using or solar. Okay, so the light intensity makes the nanomaterial vibrate at a frequency to produce heat, and that heat was used to heat up the IV fluid. So we had a solution in the technical terms, and he had a problem in the biotechnology field, and we just collaborated to provide a better solution for the people in the up north, or the people where there are, to the people where there is medical requirement and no electricity. Okay. So here we had created a portable blood testing device. Usually if you go for a blood test, it takes hours to get a report. So the entire facility was brought into a small chamber like thing, which can, you know, which is wearable and can take continuous, you know, which has very micro needles. And now that that technology is possible, you can just, the person can just wear it, and just the blood testing can be done using that component. Okay. This is a farming device. A college student came up, like, you know, he is from a farming background. He's like, you know, to put the seed at equal distance is very difficult. So he came up with this problem, and we built a farming shoes which can be worn, and the person can walk and just tap. And when he taps, the seed from the lower bottom gets released into the soil. Okay. So we can actually help you in a similar way. If you have an idea, or if you are working on a research, you can just interact with us, and we can provide you with an optimal solution. Okay, so thank you. I'll just share my screen with the next speaker. Thank you.
Hi, thank you very much, Pooja ma'am, for a very informative and inspirational session on patenting, filing, and trademark filing, and also for creating awareness about how to protect your ownership of individual research work. Now, may I now invite Dr. Urmila Sarkar to introduce our next speaker, Dr. Dinesh Walune, to our participants. Over to Dr. Urmila Sarkar.
Good afternoon, everybody. I'm here to welcome Dr. Dinesh Wanule. Dr. Dinesh Wanule is a faculty of zoology from Birla College, Kalyan. He's been there since last 10 years. And Dr. Dinesh has done his master's with specialization in entomology from Swami Ramananda Marathwada University. He has done his PhD from Swami Ramananda Marathwada University as well. And his topic for PhD, was studies on insects as sources of antimicrobial agents. Sir has also done postgraduate diploma in bio-nanotechnology from Mumbai University. Sir has more than 20 research papers to his credit in national and international journals. Sir has been awarded with 7 patents, and Sir has received Rajiv Gandhi National Fellowship, and today sir is going to speak on Patent Law 1970. So sir, I welcome you for this talk, and over to you, Dr. Dinesh Wanule, sir. Thank you.
Thank you very much, Dr. Vanika Kamath ma'am, for such a nice introduction of mine. Today, I am going to talk on one of the very important topic, that is Patent Act 1970. Basically, I would like to tell you that I am not by professional as a lawyer, or I am not even student of law, but we have gone through this process of patent filing and some hurdles that we faced and we learned. So I would like to share my experiences through this particular topic, because when it comes to the legal format, then we have to face certain legal terms and then we may got confused. I hope I am audible to all.
Yes, sir.
Yes, sir.
You're
Yeah,
audible.
thank you very much. So we face certain problems while answering the questions raised by the controller of examination or the controller. Then we may get little difficulty if we have not filed our patent through the patent agent, and then we have to need help of the patent agent. So I would like to introduce few of the terms, few of the sections which we must know before filing the patent. So we will not having any trouble during the patent filing, patent application filing. So I will also explain the process of patent filing. I will share my PowerPoint presentation with you on screen. Is it visible?
Yes, sir.
Yes,
Okay,
sir. Yes.
thank you very much for confirmation. So Intellectual Property Rights Patent Act 1970, it was come in force on the 19th September 1970. Before that, there were many committees were formed to bring this particular act, but they could not succeed after the independence till the 1970. And in 1970, this particular act got passed in the parliament, and we have our own patent, Intellectual Property Right Patent Act 1970. Before independence, we have the British law and the patents that filed under the British law. So this is our own act. So this act, it brought in 19th September 1970, and this act it is included. There are 23 different chapters. So whatever the related with the intellectual property right, patents and various aspects, they are covered in these 23 chapters. But because of the time constraint and whatever the need to the researcher regarding the filing patent, that this chapter we will be cover mostly the chapter related what can be patentability, non-patentability, and what application, section for application, publication, and grants, and what are the rights of the patentee after the particular grant of patent. So chapter 1, that is a preliminary chapter. It described about the definitions which are used under this particular act. So clearly mention what is patent, what are the what is patentee, because these terms are very important through the legal viewpoint. So there should be having a clear cut idea about every single word and its meaning. That is very essential when we talk related with the legal aspect. So this chapter 1, it is related with the preliminary, or we can say the all the definitions related with the patent that is defined in the chapter 1. So this chapter 1, it is mention what is patent? So patent means any invention granted under this particular act. So what kind of invention? What is invention? It is also prescribed below. So invention that is related with the any new term, any new, it is relation with the any new invention and which is having a industrial application. So any invention cannot be filed as a patent. The invention which is having particular industrial application or commercial application, such inventions only can be considered as a patent. So patent is a particular invention which can be sanctioned under the particular act, and patentee means the person who filed the particular application of patent. So patentee, who can be a patentee? A natural person, a researcher, scholar. He can be a patentee, or on the behalf of the patentee, any assignee can file application in the patent office. So there are 4 patent office in India, and in any patent office you can file the patent application. So patentee is a person, he's a natural person, or on behalf of him, any other person, or the patent agent, he can file the application. Then patent agent is a registered person under this particular act. So he has a knowledge about the entire process, and on behalf of the patentee or the researcher, he can file your application in the patent office. Then next definition, that is capable of industrial application. So patent you are filing, it is a novel, and if it does not have any industrial application, then definitely it cannot be considered as patent. It will be a simple invention. So it is clearly defined under this act, because this is a commercial aspect. This your invention must having any particular commercial angle, or it must have an industrial application. Then only you can file your invention as a patent. Otherwise, it cannot stand in front of the examination committee and you will not be granted a patent. Then invention, here under the section 2(1)(j), it is clearly mentioned that your invention must be a novel and having a industrial application. Many times there are remarks from the examiner that your patent lacking in the section 2(1)(j). So we may got confused. What is section 2(1)(j)? And then we need some help. So here it is a section 2(1)(j) mentioning the invention. So if the examiner do not found any novelty, newness in your patent, then definitely it will not be considered. And second thing, that is capable of industrial application. Then next, section 2(1)(j)(a), that is related with the inventive steps. So as we do practical, we have protocol and we follow protocol. So that is step-by-step instruction given to the student, and you are disclosing the entire process. So similarly here, the patent must have inventive steps. So you have to disclose all the inventive steps. Otherwise, there may be a remark that section 2(1)(j)(a), it is not mentioning the inventive steps. So when you prepare a draft of patent, you have to disclose all the things, whatever you did in during the research. So all these steps you have to mention in the draft. There is no need to hide anything. Otherwise, there will be remark on the section 2(1)(j)(a). The next section, that is the section 2(1)(i), that is related with the new invention. So your invention definitely having a novelty. So if your research work, your invention, it falls under this particular three category, then definitely you can think about filing a patent. Okay, but there are certain contradictions, and under this contradiction we cannot file the patent. So in 1970 Act in chapter 2, it is clearly mentioned what can be patented and what cannot be patented. Like the section 3, it describe about the non-patentable. So what research cannot be considered as patent, or you cannot file your invention as a patent. So section 3A, it is the frivolous type of your invention. So invention which is a very natural, that has to happen after doing certain steps, that has to happen naturally. So whatever the invention based on the natural laws, that cannot be considered as a novelty. Okay, then if it is not having any serious importance, serious purpose, just a you are filing a very simple kind of natural laws principle or known things, on such things you are filing a patent, then it will be considered as a frivolous. Then section 3B, it is related with the invention with the primary intent used to the commercial exploitation of which could contrary public order or morality, which causes serious prejudice to human, animal, plant life with or the health or the environment. So any invention, whatever it may be very your novel, but it is causing damage or injury to the mankind, or it may be affecting negatively your environment, health of plants or animals. So such inventions cannot be filed as patent. So if you have developed any new explosive, on explosive invention, you cannot file the patent, because these explosives can be used for the warfare purpose, or it can be used in terrorism. So such inventions, they are very harmful to the humankind, or any toxicant you have developed. So that might be very dangerous to the environment. So such invention cannot be considered patentable under the section 3B. Then mere discovery of a scientific principle, that is under section 3C. So any simple kind of discovery or very simple type of your invention which is lacking the commercial or the industrial application. So when you file patent and if does not fit in the this particular clause, then they give a remark mere discovery. It is not very important or significant discovery, and this lack the particular importance of patenting. So they give remark mere discovery of scientific principle. Then section 3D, that is mere discovery of new form of known substances. So something is already invented, and you are also disclosing the method or a particular product again with the already known principle. So such inventions can also not be considered, and there will be a remark of mere discovery of new form of known substances. You have developed, for example, a copper oxide nanoparticle with a novel method, but copper oxide nanoparticle, they were already discovered, and their properties are also known. So you cannot file a patent on the basis that you, through the particular process, you have filed the particular patent on product. But of course, if it is your process of synthesizing the copper oxide nanoparticle is new, so you can file patent on that basis. So Pooja ma'am already told you about the different types of intellectual property. Now, utility patent, it has basically it can be filed for two purposes. One, that is the process of making particular product. If your process of making that product is novel and it is eco-friendly or economic, so definitely it can be considered for filing patent if it is that particular product has a commercial importance. Or another utility patent is for the product. So you discovered an entirely new product. So that can be also considered under the utility patent. But both the things, if they are novel, whether it is your process of synthesis of that particular product and your product, both the things are novel, then definitely for both the things you can claim under the patent. Your product is new as well as your process is also new. So this come under the utility patent. Then section 3E, that is substance obtained from mere admixture. So something which is having the property, very similar kind of property, and two different chemicals you are combining together and which is having the same property, such things cannot be considered for patent. For example, any particular drug, it is having a anti-diabetic property, and there is another drug which is also having an anti-diabetic property. You mix both the drugs and you are claiming that this is a novel uh, process or novel drug you have discovered. Now both the drugs having the anti-diabetic property, and you are not inventing any new property out of which. So it is a mere admixture of the two different chemicals or two different drugs. So such things cannot be also considered for patent. Then section 3F, that is a mere arrangement or rearrangement or duplication of known devices. So many times we do the parallel research. Once we have already known and on the same path, we are doing the another research by simply changing few chemicals and that lacking the particular principle, or you are rearranging the things and you are publishing it. So it will not be considered as I have given one example of silencer here. So silencer, the basic function of silencer is the exhaust of gases, combustible gases from the silencer, as well as removing or reducing the various harmful gases. So here we can see now one this silencer, it is having a rectangular pipe, and here the another silencer having a circular pipe. So this is just we can say a mere rearrangement of the particular product. We have not done much of the thing. We have not work on the any basic principle of this silencer. So it is just a mere change in the shape of the silencer. So such inventions cannot be considered under the utility patent. But of course, this can be filed under the design patent, because you are now changing the external features of the silencer. So this is a totally new design, and this one is also a new design. So it can go under the utility, under the design patent and not the utility. If we file this patent under the utility patent, so there will be a remark that this is a simple rearrangement of the particular product, and it will not get sanctioned or grant. Then next, that under the section 3, very important, that a method of agriculture and horticulture. because these methods are very essential for our survival, and we are depend on the agriculture. So government in 1970 itself decided that these two methods cannot be considered for the patenting. If someone file the patent on the any agricultural process or horticultural process or method, it cannot be considered. Okay. The reason behind the if anyone file the patent on the method of agriculture, then farmers has to pay the royalty, and they have to buy this patent from the patentee, and it will be really costly. And then all the products come through such patents, they are also very costly. So initially government has described that uh, these agricultural methods and horticultural methods cannot be patented. Then section 3I, that process of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, these also cannot be considered for patenting, because these are directly related with the health of the society. So methods of administrating drugs cannot be considered for patenting, or any surgery method that cannot be considered for patenting. If these method come under the patenting, then surgeries become very costly, and it is not then afforded by the very poor people belong to the community. So it is very essential considered by the government, and they ruled out it from the Patent Act. Then section 3J, that is related with the plant and animal patents. So we cannot file any patent on the discovery of plant or animal, because they are already present in the ecosystem, they are part of ecosystem, and it is natural one. So we cannot definitely file the patent on the discovery of plant or animal, but the microorganisms were excluded in the very beginning, and now the varieties of microorganisms and the seeds that can be filed as a patent. Because microorganisms are extensively used in various biotechnology processes. So microorganisms which modified genetically, that can be filed patent, because it is used in industry, and to create a monopoly in that particular industry, government has sanctioned the genetically modified microorganism as a patent, or their products as a patent. Then section 3K, that is related with the mathematical and business methods, or the computer programs per se, algorithms that cannot be filed as a patent, because this is an entirely different type of intellectual property. Pooja ma'am has already told you about this. So this, if you want a particular rights, so you cannot file these computer programs or the business methods under this, but as a copyright you can file. So instead of filing patent, we need to file it under the copyright, and copyright has a very good we can say benefits, that copyrights remains with the author up to his survival, and after his death another 60 years the rights that will be with the nominee. So author can nominate any person, and after his death all the royalty which is gained through that copyright, it will be given to the nominee. So mathematical expressions, if you want rights, or computer programs you want right, you can file, instead of patent application you file the copyright, and that is very I can say useful for a researcher. In some country, computer programs definitely they are allowed to file as a patent. Now, Patent Act 1970, it is only up to our territory of the Indian government, and it is not beyond the territory, and it is not applicable. Our Patent Act is not applicable to any other country. It is only applicable in our country only. So patent is territorial right. If we are seeking the rights of our invention in any other country, obviously we have to file application, separate application in those countries. Okay. Then literary and dramatical and musical artistics, all these come under the Copyright Act. So these forms, these are the intellectual property, and basically they also having the commercial importance, but government has decided that it must be considered under the Copyright Act, and Copyright Act is universal. It is not like the Patent Act, it is a universal. So you have filed copyright for that particular form of art, it may be literary or dramatic, it is applicable to the universe. So it is a universal right. Wherever that is your creativity, it is used for the commercial purpose. So that person has to take permission from the author, and then only he can utilize that particular creativity. Otherwise, that universally it is accepted that it will be violating the Copyright Act, and then the author can file case against such persons and can ask for the justice. Then next, section 3M, that is a mere scheme or rule, method performing mental act or method of playing games. So methods of playing games cannot be also patented. Pooja ma'am has already shown you one patent on the chess. So that simultaneously 4-person or 8-person can play that chessboard. So it is a entirely new, it is not a method of playing the game, but it is a design of that chessboard. So it come under the design of the patent. Then next, that any presentation, it cannot be considered under the Patent Act, or if you want to take right, again I can suggest it can be taken under the copyright. Then topography or integrated circuit, that also come under the Copyright Act and not the patents. So these things cannot be considered for patentability. The next, an invention which in effect is a traditional knowledge, or which is an aggregation of the duplication of known properties of traditionally component or the components. So anything, your invention, which is based on the traditional knowledge. Now, traditional knowledge is particularly the rights of the traditional people, the tribal people or the local people. It is their treasure, and since they are using since many generations, and it is practiced and it is well known, then definitely such inventions cannot be considered as patent. And there are many examples for this, like the haldi or the Azadirachta indica, that is a neem plant patent, which were earlier filed in the United States, but we have filed a case against that, and we shown that we used these chemicals like the haldi or the neem since many generations, since antiquity, and it is well documented in many manuscripts. So you cannot claim as a novel, and we fight that case in the international court, and these companies, they have to withdraw their patent application. So anything that is related with the traditional knowledge, that cannot be considered for patenting. And very important section, section 4, that is a invention related with the atomic energy. So anything, any invention with the nuclear energy or atomic energy, that cannot be considered for patenting. Though you have developed any new process or new product using this, because it is again affecting your that section 3B, that is a public order and morality, and it may cause a great damage to the particularly the humankind. And nowadays we are using nuclear energy for the production of electricity. So there also we cannot use, such invention cannot be used for the patenting. So this is a very these two units are very important for researchers, so they can examine on their own whether my invention, whether my research, it can be filed as a patent or not. Otherwise we consider that our patent is our invention is patentable, and then we file it and we wait for 18 months. So it will get published and it will get examined, and that after that we will come to know that no, it is someone already done, already filed patent on that. So that will be our great loss. So we, on our behalf, we must judge our invention, study our invention through these viewpoints, whether it is a new invention, whether it has a inventive steps and has a industrial application. If your invention basically successful in these three category, then you see whether it is contradictory to these sections, whether it is a frivolous type or it is a contrary to the public order or morality or mere discovery, and then definitely we can go for patent filing. Okay, so these two chapters are very important. So once we know that yes, my patent is my invention is worth and I can file it as a patent. Now there is a process for filing application. So that is described under the chapter 3. So sections 6, it is describing the person who can file the patent. The inventor, on behalf of him, he can file the patent, or the particular company can file the patent on behalf of the inventor. But here these two terms, one that is a inventor and another that is a applicant, it come on the form or the application. So it is very significant because we are the researcher, so we are not knowing who is the inventor and who is the applicant. So inventor, basically the scientist researcher, he can be an inventor, and applicant on behalf of the inventor who filed the application. But the rights of that particular invention, it will go to the applicant and not to the inventor. So when I am filing patent and I want to take all the advantage of the patents, so I must be applicant in the form while filing the application. Okay, so inventor, he cannot take all the advantages or commercial advantages of the patent. Only applicant who filed the application, he has rights of using the all the rights of the patent. So if I am a natural researcher, I am the inventor, I, on behalf of my name should be there in the application as a applicant. So that is very important. Otherwise, I will lose all the economic benefits which I may get through the patenting. Somebody else will take all the advantage of that patenting. So who's the applicant? So we have to file the application, and after filing the application, uh, it will go for the publication. So before that, this chapter also discussed about what type of application you can do. So there are basically two applications. One is the provisional application and another is a complete specification. Now what is provisional? Suppose you have idea in your mind, but to in order to complete that idea into reality, you required some time. But same time you have a threat that somebody else can also work on that particular idea, or steal that your idea, and he can file the patent before you. So in such case, what we can do, we can file the provisional application. So you will disclose your concept, and government will give you time for doing work on your idea and to bring it to the reality, to make it factual. So government give you 12-month time to complete the entire process, to form a new product or new process. So you can file the provisional specification, and after completion of your process, the novel process and the novel product, you have to file the complete specification. The advantage is that invention, it will be considered as you have filed first. So it is just like a first come first serve basis. So it will be mentioned that on that so and so date and so time, this invention is already filed. So no other person can claim the same process or the same product as a patent. Okay, but you have already done all the process and you have discovered a new process as well as a new product or any one of them, then you can go directly for complete specification. You can directly file the complete specification with the complete disclosure. So no need to hide any step or any process, because it will be examined thoroughly by the expert examiner in that particular field. There are various categories, and in every category there are experts, and they will see that whether all the steps are correct or not. And this is very essential that while filing the patent, you disclose all the things. Then under chapter 4, after filing a application, so mere filing application, it does not work. You have to file another application, another form for publication of your patent. So under chapter 4, section 11A, you have to file a application as the application format is given by the controller of examiner. In that particular format, you have to file a separate application for publication. So your patent, it will get published from the date after the 18 months. So it will take a time of publication of 18 months, but nowadays there is a little relaxation. If you are a new you are started a startup, and this startup, if they are filing the patent application, their application is published within 1 year and examined also, so that their economic progress they can do. There is not much loss of the their economic progress, because their economic progress means the progress of the India also. So startups, industry, they can file the application, but their fee structure is little different as the fee structure for the regular application. So regular application, it will take for publication 18 month, and after 18 month of publication, if you have filed a application for examination, then it will be examined by the controller and other examiners. Controller will assign that particular application to the examiner, and it will go to the examiner, and examiner will examine your application. So that will take another 48 months, up to 48 months it will take. If you want to expedite this process, you can file under the startup, or extra fees you can pay and you can expedite. Even any applicant, it is a suppose a woman scientist, her application is also expedite under this process. Such provision is now given, but it was not earlier present in 1970 Act. This is amended later on. So normal process, it will take 18 months to publication. So your invention will be published in the Indian Journal of Patent, and we can found this Indian Journal of Patent on the Indian Patent official website. And this is also very useful to study what type of patents are filed. So just like we do review in case of our research work, we study review articles. So similarly here also, while filing patent, or if you want to work in a particular area, you can go through these patents and you will get ideas whether we can work in that particular area, or up to what level the work is already done. So this is also very essential. We can go through the patent official patent website. Then, as I already told you, that you have to file a separate application for examination. So under chapter 4, that after publication, we have to request to the controller, please kindly examine my application, my discovery or invention, and the controller of examiner, as I told you, after the publication and after application of 48 months of the date of filing, he has the right to the examine, but only after your request. So you have to request in a particular form that please kindly accept my application and please examine. So controller, it will direct your the patent application to the respective examiner, and examiner will go through and generate a examination report, and it is called as FER in the patent. FER, that is a first examination report. Now first examination report, the examiner, it may be agree, it may understand your all the invention perfectly, and he has no objection on your invention. So such examination report, it will given to the controller. Then controller has right to grant particular patent. Or there may be some questions which are unsolved in the mind of examiner. He can address these questions to the controller, and controller will send the same query in the form of FER to the patentee and ask them to give justification on these questions, whether it is related with the atomic energy, or whether it is a mere discovery. So such questions may be asked, and we have to answer it satisfactorily in the writing prescribed format. So we are not going to discuss the prescribed format because it will take very longer period of time, and the authorities, the patent agents are very good in that. So the controller has the power under the section 15 that he may refuse or he may ask for amendment in your application, or he may grant your application as patent. So after generation of FER, you give answers, and if those are satisfactory, the grant will be given to your patent. Otherwise, he may ask for hearing. So you have to stand in front of the controller and examiner for the hearing. So hearing, it is taken virtually or in the physical form. It is if it is accessible. For example, we are in Mumbai, and your examiner and controller is also from the Mumbai office. So he may call you on a particular day, on particular time for hearing, and then you can go and you can explain your entire process of patent or product, and novelty related things, patentability related things, and he will take a judgment on your hearing. Otherwise, for example, you have to face hearing from the Kolkata office or Delhi office, then you can go to the near patent office, Indian patent office, and there you can ask for the virtual hearing. So they will make arrangement on the particular time, and otherwise they will provide you link, and on at your end also you can give answers, either the inventor or the applicant, or on the behalf of applicant, the particularly agent, patent agent can also give the answers. Then Patent Act 1970 Chapter 8, if everything goes very well, the controller of examiner as well as the controller as well as the examiner, they got satisfied with your patent, they will grant you patent under the section 43. And then we got certain very exclusive rights of the patent. So these rights of to the patentee after the grant of patent, it is disclosed in the section number 48. So what are the rights to the patentee? One, act of making. Act of making using means you can utilize that particular process and only exclusively by you. No third party without your permission can make use of your invention or your product, your process or your product. Only you have the monopoly. Only you can, in entire India, only you can utilize it. Okay. Then you can sell your patent to any industry, and against that you can get the royalty money. So this is the another advantage we will get after grant of patent. And the third one, that we can import the things, raw material which is required for the process or the product. So these are the exclusive rights given to the patentee, and it is related with the economy. So we can better judge our invention, and we can ask the royalty money to the industry. We can approach industry, or nowadays the MSME, through MSME, many industries, they are contacting such patentees, and they offer the royalty money. So this royalty money can be decided by you or it can be decided by mutually. And as long as they utilize your intellectual, this in the form of process or the product, you will get the royalty. But the only thing that we have to, every year we have to pay some fees to the government to continuation of the patent. That is a small amount that we have to pay to the government every year. Otherwise, the patent will become open, and then after 3 years, any industry can utilize that patent, that particular process without your, even without your knowledge or concern. Then second thing that we we will get under section 48B, that we can prevent any third party of make use of our intellectual, our patent under this particular section. And if you found that any person is misusing or without giving a proper we can say concern, your concern, they are using that particular process or patent, we can file case against him. And penalties are also prescribed here in the Patent Act, but we will not discuss about these penalties. Penalties, they are both form imprisonment or the we can say the penalty in the form of money. Monetary penalties are there, or both can be applicable. So this particular we can say right is with the patentee, those who grant the particular patent for 20 years. Patent has a life up to the 20 years. Okay, since you file the application, from that day to next 20 years, all the monopoly rights will be with you. And after 20 years, it will be open for make use by the industry or by the society. So these are the different rights given under the Patent Act. Then one more important that is section, that is section 54 under the chapter 9, that is patents of addition. So when you filed a complete specification and you found that you need to make some changes or modification in your complete specification, you found that some new ideas, and based on the same principle, then definitely you can file the another application for the patent of addition. So this will improvise your patent. It will not be considered as entirely new patent, but this will be considered as patent of addition, because you have already filed the patent on the same process or the same product, but as it is in the particular process of publication or examination, meanwhile you also discovered some new things, you modified a few steps, and that really improvise your earlier disclosure. So you can file the patent of addition after filing the complete specification. So these are the many things that we must consider while filing a patent. So I tried my level best to discuss some of the chapters which are required by the researchers before filing the patent. So this is all from my end. Now this is over to the organizers. Thank you very much for giving me opportunity and to share my views and my experiences related with the Patent Act 1970. Thank you very much.
Cheta madam, your mic is muted.
Okay, thank you, sir. Yeah. Am I audible now?
Yes,
madam.
ma'am. Yes.
Yeah, thank you. Thank you very much, Dr. Dinesh Walune, for making us familiar with salient features of Patent Act 1970, Copyright Act, and Term FER. Now we are into question answer session. I request all participants who wish to ask any question related to Patent Act, IPR to our guest speaker, they can type it on a chat box or they can unmute and ask question. Meanwhile, I'm having three questions for the speaker. First question is, will you guide on a royalty one gets when patent is utilized commercially?
Will you guide on royalty one gets when patent is utilized? Okay, ma'am. Okay, I think the question is asked by Vanita. Vanita, madam, see, whenever we talk about royalty or commercialization, the price is negotiated between the person who buys it and the person who is selling it. And there are different types of royalty involved. One is the entire patent gets, it gets sold, right? The person who is buying it, they'll buy the entire equity of your idea. Other is they'll provide you with an initial amount, and then there is a piece by piece royalty by like month wise or year wise based on the sale made. Or else they'll negotiate that if once we'll do all the R&D, and once the product is in the market, we'll provide you with certain royalty. So all these terms and agreement is drafted by the patent agent or the agency who is involved in it. We can definitely help you in that perspective, but what is the estimation of the product can be decided by you and the person who is purchasing it, depending upon the market study, the statistics, the requirement, and all such things. See, like for example, if you talk about big machineries in the medical center, although they are very useful, maybe 100 pieces a year, okay? But when you talk about a single pen, right, the costing would be very less, but the utilization and the mass that in which it is sold is different. So it depends upon how much pieces are going to be accepted in the market, the level of requirement, and the frequency of which it is manufactured. But we can help you to look into all those perspectives once your patent has been filed. But you can only talk or discuss about the idea once the application has been applied. Thank you.
Thank you, Pooja ma'am. There is one more question. How teachers from fundamental science or a core science can file patent, and how they know whether their research is patentable or not?
Okay. First of all, if you're entering this field for the first time, the if anybody has applied for a patent, then the data will be open. See, we are hum antaryami to hai nahi. So how do we identify whether your content is patentable? Is that we search in different databases, maybe published papers, open databases, blogs, official patent databases of different country like India, US, Germany, which is open for everyone. Every country has to mandatorily publish the data within a few time span. So once that data is published, anyone can see through that content and can identify whether the content is patentable or not. And as I told you, we as a team will help you to find patentability in your content. We'll be going through your data, we'll be performing the prior art verification, and then identifying whether this idea has ever been disclosed. If not, we will provide you with a base to file for a patent. We'll be helping you in that perspective too.
I would like to say that please do good collaborations with those people, those who are working in applied field. So definitely applied those who are researchers, those who are working in applied field, they also require people from fundamental knowledge. So here we have to bridge this gap of knowledge. We have to come together, we have to collaborate, and we have to do the interdisciplinary type of approach. So definitely the fundamental, those researchers who in the fundamental field, they also can become a applicant for patent, and they can also be inventor. So it is a teamwork basically.
Yeah, thank you very much. Thank you very much for your offer. We will definitely come to you and take your guidance. There is one more question from a student, Akash. How can one become patent officer, and what is the required qualification for that?
Okay, this is one of the biggest, I think, opportunity which people are not aware of. Anybody who wants to be a patent examiner, there is an exam for patent examiner and for patent agent, and the minimum qualification that is required is you should be from a science background, whether you have done your masters, not even masters, like your bachelor's or masters. It's more than enough. Only a science degree is required. Lawyer बनना भी जरूरी नहीं है. You do not even need a lawyer's degree. And every year they have a patent examiner examination in whichever field you have your expertise in. See, whenever you submit your document, the expert in that individual field, like if you're from biotechnology, agricultural science, zoology, the expert will, go through your document, do the search and examination. So if you are an expert from the field of zoology or maybe engineering or civil, you will be appointed as an examiner in that sector, and you will be provided with, the documentation, the examination facilities. So there is an examination every year. In this month of May, in this year, in the month of May, the examination for patent agent is going to be conducted. The only qualification needed is you need to be from any science background. So even you can apply. The difference between both is if you are a patent agent, you can start your own company like us, and you can help others to file patent. If you are a patent examiner, you will be recruited into one of the patent registry in India. So you will be working under the government. So that is the difference. Thank you.
Thank you very much. This is really precious information to our students and all the participants. Yeah. Any other question? Students, if you wish to ask question, you can unmute yourself, because in question ask session, we have given facility to unmute yourself and ask question. And feedback form, yes.
Hi, Pooja ma'am. Good afternoon, and sirs to you as well. I had a question. Like I have been a child who was, with a child from like early age. I have been like done so many experiments and all, but I have never patented anything because I didn't have that knowledge to do so. I say, for example, for now I have an idea that let's say there are two things. There's one bone conduction sound system, and there is one normal sound system where we use a speaker to get the sound in our ear canals. Now, if
Okay.
I combine both of those and make a more complex sound system, say for an example, an earpiece, can that be patented? Like because there is a design change. Can that be patented in the design change wala thing, or that the other patent wala thing? Like
Okay.
yeah.
I understand your question, sir. Now let me just brief you. Now suppose there are two different technologies, both are individually patented, but you found a way to collaborate and to provide a better facility, right? So that is what you're asking. So in that circumstances, if you're collaborating two patented technology into one to provide a better output, additional input is required, and different type of features and enhancement is possibly available, the output is different, you can apply for a utility patent because the technology is getting combined where input, output, method, facility, advantage all needs to be described. Apart from that, if you are designing a different earpiece to accumulate the newly created technology, the structure of the product can also be applied for a design patent. So that is what I told you. एक प्रोडक्ट है तो उसमें यूटिलिटी भी हो सकता है और डिजाइन भी हो सकता है. यूटिलिटी उसके आइडिया को प्रोटेक्ट करेगा, उसकी वर्किंग मेथड कंपोनेंट्स को प्रोटेक्ट करेगा, डिजाइन उसके स्ट्रक्चर को प्रोटेक्ट करेगा. सो यू कैन गो फॉर बोथ. बट सिर्फ ये देखना है कि बहुत जेनरिक नहीं होना चाहिए. कोई भी आपके फील्ड में एक्सपर्ट है तो ऐसा सोचना नहीं चाहिए ओ ये तो ऑलरेडी अवेलेबल है, ये भी अवेलेबल है, मैं कंबाइन करता हूँ तो A+B. इतना जेनरिक नहीं होना चाहिए. देयर हैज टू बी सम एनहांसमेंट व्हिच मेक्स द आइडिया नोवेल एंड एप्लीकेबल. Yes, Dinesh, sir, please.
Sir, please unmute yourself.
Sir, you're not
Wanule, sir.
mute.
Okay, I want to request you, please don't disclose all these ideas. Okay, once you disclose your idea, somebody else will file that idea as provisional patent, and you lack that novelty then. Okay, so don't disclose, and then see at what extent there is a change. Okay, otherwise you are combining two things together, so it will come under the mere admixture. there is always a remark as your invention is a mere admixture of the two things. So you have to prove them that at what level you are improvising the particular property. That is very important, because the two different things, they are already patented and their principle is already known. So there is a question that lack of novelty. So you have to prove them, sir, we have done this and this makes certain changes and it has a great commercial or industrial application. So these are my two advice to the sir. Thank you very much.
Thank you so much, sir and ma'am. Actually, I'm a student of BSc first year, so yeah. But it was a great pleasure talking to you guys, and I got to know a lot of things, and it was really eye-opening experience for me. And probably I will do my first patent within a year. So thank you so much.
Wish you all the best. And any help you require,
Thank
please
you.
contact us.
That's
We'll
really,
do. We'll surely do that.
yeah. There is one more question. Uh, can you give us information about the exam name of patent examination? Under what title the examination is carried out? And one more question.
Pooja madam, could you answer this question?
Yeah.
Sir, actually my network had some issues, so can you just repeat the question, sir, please? Yeah, ma'am, please.
Exam name of patent examination. Exam
Okay,
name.
there is no, yeah, see, there is no particular name. If you go to the website ipindia.nic.in, and there is an update column. Okay, so if you just ipindia.gov.in is the official Indian trademark and design website. If you go there, there's a news update column. So they keep on updating it every day. So if you just have a quick check, like maybe once in a month, see if you're connected with us, we'll let the institute know that the exam is upcoming. So usually they have it scheduled every year. For patent, they have it scheduled every year. For agent, they have it scheduled every 2 years. So you can, I'll let you know, but you can just check the news update. So it's called a patent examiner examination. So they'll publish it so you can have that examination. So it happens every year.
Yeah, thank you. And one more question. Can you suggest any certificate course for IPR?
Okay. See, if you're talking, see, there is law. Okay, so you can have a diploma, apply for a distance education for IPR degree, or maybe get into a college and get an IPR degree. But apart from that, just about certification, again, log into ipindia.nic.in. Every like once in a month, they have this certification where they actually teach you how to draft and file a patent. See, even we as a company do the workshop for an entire day where we provide the entire drafting filing experience. But apart from that, even IP India as an official government, they have a 2 days, 3 days, a week course for IPR teaching. So they do that. And apart from that, World Intellectual Property Organization, WIPO, also does different certification course where every different services like patent drafting, patent search, examination, objection reply, they have individual courses for that. I think twice a year. So you can just log into WIPO, WIPO, and you can check for certification courses. They are doing it in collaboration with our Indian registry, or else you can just always check into IP India. They always update their, if they are upcoming certification courses, even if they are in collaboration with Japan, Japanese registry or Indian registry, UIPO or anything. So you can just log in. They have different certification courses continuously throughout the year.
Okay, thank you, ma'am. Now, I request all the participants to fill feedback form. The link for the feedback form is posted on our chat box. Now, I request Professor C.M. Joshi to take the charge to offer word of thanks.
Yeah, thank you, ma'am. Am I audible?
Yes, sir. Yes.
Okay, thank you very much. I feel very proud and privileged, and I'm very pleased to propose this vote of thanks on this very important webinar on legal dimensions of intellectual property rights. Ladies and gentlemen, in post WTO regime, since IPRs can bring billions of dollars to individuals, to institutions, and to countries, there has been a mushroom growth in intellectual property rights across the world, and India is also not lagging behind. हम देर से आए लेकिन हम दुरुस्त आए और हम दूर तक जाएंगे. With this particular belief, let me propose vote of thanks for this national webinar on legal dimensions of intellectual property rights. We were very fortunate to have Lieutenant Dr. Kantilal Nagre sir as keynote speaker. Sir, you set the ball rolling, and it was from the horse's mouth that we all got motivated, and the kind of energy and enthusiasm you have shown, you have worked and you have been working in this particular area was very motivating. We are very grateful to you, sir. Then Miss Pooja Menon, she took us to the world of patent, starting from the basics of patents with the kind of motivation she has set. In fact, it has been reflected by the question answer session where a student could get courage to ask a relevant question on this. So thank you, Pooja Madam. Then Dr. Dinesh Wanule sir spoke about the legal aspects of patent law since 1970 and the various amendments that law has, the do's and don'ts, what is novel and what is not. So thank you very much, Wanule sir, for uh, taking us to the legal aspects of the patent law 1970. On behalf of Deccan Education Society's Kirti M. Doongursee College, IQAC and Research Promotion Committee, I would also like to thank our Chairman of College Development Committee and Trustee of Deccan Education Society, Advocate Neil Helekar, for his constant support and guide and motivation. Equally, I would also like to thank our Prabandhak and former Principal of Kirti College, Dr. M.B. Kekre sir, for pushing us all the time to go for more research oriented activities. Our principal, respected Dr. D.V. Power sir, is a constant support and as a strength of a pillar of our strength. He has been motivating us. He keeps on pushing us, and we are fortunate to have him as our leader. So thank you, Power sir. Then all our vice principal, Dr. R.B. Kaude sir, Dr. Meenal Mapuskar madam, she is also life member of Deccan Education Society, and Professor Vitthal Sontakke sir, another Prabandhak of Deccan Education Society. They keep motivating and keep supporting us in all our endeavors. I would also like to extend my heartfelt thanks to in charge of self-finance programs and convener of Research Promotion Committee, Professor Dr. Seema Sapre, for her constant support and guidance. Our IQAC coordinator, Professor Matthew Samuel, our convener of this webinar, Dr. Vanita Kamath, organizing secretary, Dr. Subhas Donde, co-convener of the program, Dr. J.R. Mahajan, have put extra efforts for this program to see the light of the day. I would also like to thank all the heads of the department, senior faculty and participants from all parts of the country. I mean, we could go as east as to Mizoram. We had participants all the way from Mizoram. So thank you very much to dear participants. You have made our day, and the program has been a good success. Any program, whether on offline mode or online mode, needs support of a lot of people. So there have been technical team, there have been people behind the scene. I would like to place on record my sincere thanks to all the members of IQAC, Research Promotion Committee, non-teaching staff, support staff for technical assistance, and finally to dear students. So on behalf of IQAC and RPC, once again, I would like to thank each one of you. Thank you very much. And over to Chetna, madam.
Thank you very much, Joshi sir. Now, it was really wonderful session. All three sessions were